Hi, everyone. It says I'm alive. Yay. The camera says you're live. How is everyone? Do the YouTube-y thing. It's so funny, tennis girl. She's so funny. How is everybody? So I thought there's a couple update thingies for courts today. And someone asked yesterday if Sigfredo Garcia had an open appeal, and he does. He has an open appeal with the Florida Supreme Court, which we'll go over. So I'm Patty Wilson. If you don't know me, this is Patty's Playhouse, and we talk true crime and focus a lot on the Adelsons. Donna Adelson, of course, is going to be on trial in about 12 weeks, something like that. Less than 12 weeks now. Starting June 3rd, and the transport orders for her son and his son's partner in crime, Catherine Magbanua, is out. So Catherine's at Lowell Correctional. It's near Ocala, Florida. And Charles J. Adelson is in South Dakota for his own protection. He's going to come down here and be in solitary confinement, along with his mother and Catherine, likely. We'll see if they move Sigfredo over. So Sigfredo Garcia, who was the shooter, he's the one who took it upon himself to take his gun out. He was in the passenger seat of a Prius, of all things. Get out and shoot Dan Markel in the face twice and killed him. And that's horrific. So Donna's defense, Jackie Fulford and Joshua Zellman, asked to depose Siegfried, is what I like to call him, on March 10th. So my guess is it won't be, I'm sure they'll go there. I can't imagine it's so close to Leon County that they wouldn't show up at Franklin Correctional Institute, which is in Apalachicola, Florida. It's about, let's say, an hour and 15 minutes from here. It's where my son used to work. And he's been on with me a couple times. But I bet they drive down. It's too close not to. So he can stare at them like this. He's a dunce, in my opinion. He is. But he's been smart enough to keep his damn mouth shut all this time that I can't imagine he's going to open it for them and help Donna out. He's probably just as jacked up at the Adelsons and Catherine. Well, not Catherine, maybe. I don't know if he is yet or not. But Lewis is. And Sigfredo did it for Catherine. I can't imagine that they would speak kindly of the Adelsons, or he would speak kindly of the Adelsons. So we'll see how it goes. But that is one deposition I want to get a copy of when it's done. Ooh, that's going to be a good one. He either is going to sit there and look at him like a turd on a rock, or he's going to spill his guts. But I don't think he's going to spill his guts because he hasn't spilled his guts. You're listening from the nail salon. Patty, you're shrinking. I trust you. I am not. But this... See, when you look at yourself in a webcam, it's in the reverse. So I have one shoulder shorter than the other. So which one is it? It's this one. Because I can't tell because it's reversed and the blouse slips off. It's a mess. But I'm not shrinking. But thank you, Kimber. I wish I was. I watched some chick. She was on the Daily Mail. She went from like 315 pounds to 130 pounds on the Ozempic. Still, it's a lot. I don't want to be 130 pounds. I mean, I guess I do. In the end, do you know? I really don't. There was a time when I would be like, God, I wish I was 125 pounds. I just don't even have the will. I think I have to have the will. I'm sorry if you don't know me. I laugh at myself uncontrollably for no reason at times. But I don't have the will to get down to that weight and stay. I just don't see that my life would be better for it. No. I'm working on 35 pounds. Not 195. I've already lost 100. I don't have the will to do that again. But it is funny, though. Thank you for the compliment. It's an awful case, Henry Segura, and also Tallahassee. It's also Tallahassee. So Murder by Maestro, who enters the Playhouse quite a bit, mentioned watching the trial, and I thought, oh, I haven't watched that in full. That would be a good one to watch. Because it really changed real estate in 2010 in this area. It was really, it was a big deal because he wasn't tried for a very long time. He wasn't arrested for a very long time. Justice is slow. Hey, Yala, how are you? Hey, Becky. So I always pretend I'm on Romper Room and say hi to everybody. Like I was Miss Marsha when I was on Romper Room. Hi, Crazy Nan. He was motivated because he didn't want to pay child support. Well, he's not paying child support. He's a wretched man. Are you in the Reddit sub? You're not talking to me because you know I am. So I made a little clip of StreamYard allows you to make clips now, which I don't know how much editing I can do from it. I haven't played around with it much, but I made a little clip of our own John Smith, also known as Elegant Hurry, in Reddit of his song, Donna's song. We'll play it before we end tonight. It's a great song. Makes me very happy. Hi, Michael. My mom just saw an interview. My mom just now saw an interview with Jeffrey Lacoste, and she's furious. I just don't know how anyone. I'm going to go at Jorge, the boyfriend, and be like, what are you thinking? What are you thinking, dude? Thanks, creative. It's very nice of you. I try to look good every day. Some days, like I was outside, our wind's like 60 miles an hour. Again, it's very, very windy outside. And I was at an appointment. I was at a listing appointment with another one of our agents. You don't think Sig will say one word? I don't, in my heart, I don't. But I would love to be there and watch him. Did you bring me a Twinkie? No? Okay. That's all I could think of. I was just debating myself that if I cut out toast in the morning for breakfast, I'd lose belly fat. But I was like, who cares? Yeah, I haven't. I don't really cut out anything anymore. I just eat one meal a day. Now, today I had two. I had oatmeal today. I had oatmeal this like 11. And it's just instant oatmeal. I'm not making oatmeal. Okay, no. And then I just had a very small sandwich. So I had two. Your husband lost 35 pounds in the last year. It sucks. Well, he was sick, right? Was he sick? I don't want Ozempic face. Yeah, they used to call it, I don't know if they still do because they are microdosing now, but Mr. Peanut. You look like you have a peanut head. I know. Looking at the Oscars red carpet definitely will send your self-esteem plummeting. Absolutely will not. Not for me. It does not. I have no desire to be like any of those people. None. I think they're wretched. I think most of them are sold their soul. And I have absolutely no, some are talented, some are just stupid. Some are up there because they're stupid, not because they're talented. And I just can't with it. So I didn't even watch it. I put together a slide that I was going to make fun of their clothing. I was like, I don't even want to do that. Like I could make fun of their clothing easily. Some of them look like, I watched this one guy, he's this little Indian guy. He's so funny. He's like, you can't have this because you're poor is his shtick. And they don't care about you because you're poor, which is true. They don't care about you because you're poor. But this one lady, I don't know who it was. she had this like big red puffy dress on, and he said it looked like an anal prolapse. And then like once you see it, you're like, it does look like an anal prolapse. Some of these dresses, they're not even paying for them. They're gifted them. It's just disgusting. I'm not one, like, if I'm watching a movie, it tends to be an old movie. Like of course, Gene Hackman died, so I'm on a Gene Hackman binge. I watched The Package last night. Very good. I'm like, I can't. I'm on Tubi a lot. Tubi, watching old movies. An anal prolapse. I was like, dude. Let me see if I can find it. Hold on. I forget the lady's name. Sarah Paulson. That's her name. I'm going to share this. I mean, come on. Do you really have to do that? Like, how do you get in a car? Like, how do you get in a car when you're like that? It's awful. He called it up. This guy is so funny. Anytime he has a video, I try to watch it. You can't, unless that's Velcroed in the back. Okay, and then she has a tattoo right there for no reason, so it just creates noise. He called it an anal prolapse. Used to be a comedian called Dennis Pennis who would make jokes at the celebs on the red carpet. He was great. I don't know this guy's name. I never remember it. But he's laying, like, he always has a hoodie on, and he's Indian, clearly. And he has a British accent, which is typical. And he's like this, and he's like, they don't care about you because you're poor. Everything's because you're poor. It's a great line. And the bag, she should have had a red bag, and she should have had red shoes. And these don't match. Like, I'm completely over the whole look. I can't even, like, you can make fun of it, but some of it's just, I sound mean when I do it. You liked Ariana Grande's dress? Ariana Grande needs an IV, okay? The girl needs an IV. It is ridiculous. I can't imagine she needs an IV. If I were her mother, I would be devastated. Like, honey, you need to go to the hospital. You do. My favorite was Selena Gomez and then Demi Moore. They were pure class. Flame hemorrhoids. Oh, it's so funny. But that's it. Ariana Grande needs to eat a bucket. I know. Or some soup. Maybe if she just had some soup. Just soup. Just a liquid. She looks so dehydrated. Like, she doesn't blink anymore. It's like, I'm sorry. I don't even want to make fun of her because as a mom, I'm just like, you're not blinking. And that redheaded guy she dumped her husband for broke up with her because she doesn't eat. I don't know a lot about dating. It's been a really, really long time. But I do know that men like to go eat. So it's like, if you're not eating, what's the fun in that? It's just horrible. Like, dude, you got to go eat. Like, I can't imagine. It's not funny, Patty. Going with my husband, like, on a date. His favorite thing to do is go to a restaurant or FSU football. It's a tie. It's like, If I didn't eat, he would have dumped me in a minute. Doesn't matter what I weighed. She broke up that family on her own. Aw. Yeah, it's very sad because she's extremely talented, but she needs to eat. Yeah, it really does look like. Patty, pull up Sarah Paulson's girlfriend. Oh, what's her name? I forget. Holland Taylor. Was she there too? Sarah Paulson's some funny lady. But was she at the? I don't think she was. I don't think she was there. Oh yeah, Holland Taylor. She was in 2.5 Men. She's hilarious. I didn't know until I knew that she was a lesbian. But I think Sarah Paulson is hilarious. She's a funny lady. She does funny impersonations. Oh, I don't know if she was at the Oscars. Oh, because of her age? Who cares? If she's happy, she's happy. I love that they're happy together. I mean, it's unusual for sure, but Holland Taylor is a beautiful woman. I mean, she's just so caustically funny. That to me would have been like, oh yeah, she looks frail too. She's definitely aged since 2.5 Men. Bless her heart. She's getting the inheritance. You got to stick with them until the end. Okay, you don't go through all of that, and just because she ages out, you get rid of her. You got to get on the will. Dennis Pennis once asked Demi Moore if it was done tastefully in an inartistic way, would you consider keeping? I gotta look him up. Oh, I know who that is. He died. Paul K is his real name. Dennis Pennis. That's hilarious. No, is he still alive? He's still alive. It was done in artistic way. He also told Joan Collins she looked like $1 million lira. It's like our very own Joan Rivers. Like, to me, I miss her. If you were like, Patty, what comedian do you miss the most? It would be Joan Rivers. She is so spot on, so funny, and so caustic and toxic. Hilarious, though. I was just rewatching this statue episode where Kramer shows up to the guy's house playing a cop. Patty, if you lost 100 pounds and it took you a long time, you're more likely to keep it off. Oh, it did. It took like 56 years. It took forever. It took forever to finally lose that weight. I had to get up to 320 pounds for me to lose any. It was horrible. Absolutely horrible. This is not. I know Scott and I, let's tell you this story and then I'll get to it. But so Scott and I were in the radio station. We're going up to the radio station, and the radio station's in a 2-story office building. It's probably not as funny to you all, but a lot of events have happened in this elevator. Okay. So when I was taking gummies, because I thought, I'll take gummies to help me sleep. There's this place called Move, M-U-V, with an umlaut. I took German, so it's the 2 dots over the U, an umlaut. And they had great gummies. So one day, I don't know anything about dosage for a gummy. Like, I knew nothing. I had the medical marijuana card, but you didn't really know about dosage because it's not like I've been smoking pot my whole life. That was it, like gummies. So I took a grape gummy, I don't know, probably the night before. It was like, So I got in the elevator, and this elevator, the faceplate of the buttons, I started to hallucinate on the faceplate of the buttons. And I was by myself, and it petrified me. I was like, oh my God, Scott, that the button plate is mad at me. Like the face jumped out. Like, I was like, oh my God, that gummy. I didn't even realize, like the night before, a grape, because the grape was spot on grape. I love it. I was like, no. I can't ever. I've never had another gummy since, but that faceplate, it was like anger. It was just, the 2 buttons and then 1 button. I was like, so we're in the elevator a few weeks ago. I like to go up with someone else now because it's very scary to me. And there's no stairs except outside the door. You have to go up the elevator. And Scott's like, there's only 2 floors. I said, yeah. Why do we have to press up? I was like, I don't know. He goes, think about it. You're inside, it closes. Doesn't it know where to go? Why doesn't it know where to go? I was like, oh my God, why doesn't it know where to go? It can only go up. And then when you're up and the door's closed, it can only go down. Why do we have to press up? Why do we have to press down? I was like, I don't know. But I told him that's a Seinfeld episode for sure. The elevators are male. I know. It's hilarious. But that day that I was like, I ungummied myself. There was no gummies in my presence ever again. You had 1 gummy in your entire life. It's legal here. My son said you'll be fine. The bed was spinning and I had 0 control. I said, why the hell did I take that? Well, I had taken them for a little while, but I switched from True Leave, which is the largest pot distributor in the United States. And I happened to work with her. She was a realtor at Keller Williams here in town. Her name's Kim Rivers. And now she's a billionaire. True story. So she was the most fabulous listing agent I've ever watched. She is the most amazing salesperson I've ever witnessed. It was something to behold. But she's the CEO of True Leave, TruLive. So I wanted grape. That's the only reason I went to this other place. I was done. You can't do weed. It makes you paranoid. Apparently it did me too. I mean, I was like, no. And then people are like, Patty, you only take a half or a quarter. I was like, okay. So this thing is barely a button top on a pen. Like it was like this big. How am I going to do that? How do you cut that? Why is that worth? Don't make a gummy then. It's a mess. What kind of gummies around here? It's just candy. Oh no, we have medical marijuana. Mm-hmm. You have to have a medical card. And when I went to get the medical card, it's so funny. Everything about that whole process was hilarious to me. So you have to go into a doctor. There's med doctors that are usually attached to the True Leave store. And there's this doctor. And I went in and he knew me from the radio. And I was like, he just asked me all these questions about radio. And he was lovely. He really was. But I was like, do I get the medical card? At the end, I was like, are you going to ask me any questions about the medical card? He just signed off on it. It was very funny. It gives you horrible anxiety. Well, they say it's the wrong one. Mine had THC. It was from Move. It was MUV. But it had an umlaut over the U. It's on Blairstone Road here in town. So Patty, now she's on trazodone for sleep. She's not taking any of that before. So let's, there's a couple things. You know, if you will follow the Karen Reed trial, Mr. Turtle Boy got in some trouble. Looks like he's in bigger trouble. He's got to stay away from, I guess, a lot of people now. I mean, he's in, where'd I put it? He's in big boy trouble. Did I save it? Oh, yeah, Karen. Where'd it go? So this is the Commonwealth's motion for records from docket. So Brennan's asking for these records. Order Special Prosecutor Cosgrove to produce to the criminal clerk's office cell phone extraction reports. And this is about Commonwealth versus Aiden Timothy Kearney. The defendant was indicted by a grand jury for second degree. And they go on to... Don't pay attention to my files. They're a mess. Leaving the scene. It goes on about leaving the scene, but they want the records about him. The records are evident. Oh, so for his trial, they want her records. The records are evidentiary and relevant. The Commonwealth intends to file a motion in limine to admit phone records, documents, witness testimonies, and other information demonstrating intimidation of witnesses as consciousness of guilt evidence. So they're going after Karen Reed's records to convict Turtle Child. The Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of computer and telecommunications devices for unreasonable delay. But he was arrested again last night, so it will likely happen. No, not last night, 2 nights ago. It's a mess. So, Sigfredo. I was looking at... Did I get rid of it? No, here it is. So here's the case from, it's called ACIS, A-C-I-S. Put this right here. So ACIS, and in ACIS is the file docket for Sigfredo. So someone was nice enough to say, hey, does he have an open appeal? And I didn't think he did, and someone else was asked, and they didn't think he did, but he does. So if you look here, this is all Sigfredo, close, close, open. Where'd it go? I messed it up. I looked at this earlier today. So open cases. Did that not take his name? Here we go. Closed, closed, closed. I had it open. Original proceedings. I literally had it. Here is, hold on, let me go to it here. This is case number... Here it is. Here, where is it open? Oh, here it is. Belated review. It says closed, but it's not. So there's a petition for a belated review. Apparently, someone screwed up, his attorney, and messed up. So here he wrote this himself. This was when he was in Bonifay. Bonifay is north of Panama City in the Panhandle. Can you see it? So petition for he has nice handwriting for a felon and a murderer, doesn't he? Sigfredo Garcia, this is his, number. This is the Correctional Institute in Holmes County. Index to petition. Preliminary statement, basis for invoking the jurisdiction, statement of the facts. Petitioner will be referred to as Petitioner Garcia. The respondent, state of Florida, will be referred to as the state. The facts of this case are reported in detail in various briefs, records, and transcripts that were on file with the First District Court of Appeal, state of Florida. That's what I needed to do. I put it in the Court of Appeals. On direct criminal review, this is his appellate number. Any documents deemed necessary to a determination of the merits. Accompany this petition in an appendix of exhibits that complies with Florida. Appendix exhibits will be identified. And here he goes. Basis of invoking. The court has jurisdiction to grant belated discretionary review of the district court's written decision. And there's the answer. No other remedy would be adequate. Proceeds, the charge, Sigfredo, Luis Rivera, Catherine Magbanua. See, he's writing this himself. Were charged by indictment information with first degree, see it, degree, murder, conspiracy to commit first degree murder, and solicitation to commit first degree murder. The charges stem from July 17, 2014 shooting death of Dan Markel. The state noticed this as a death penalty case. The pretrial, Garcia retained Sam, I'm not even going to bother, as defense counsel. Rivera subsequently agreed to testify against Garcia. He had to write this out. And Magbanua in exchange for a 19-year sentence on a second-degree murder, concurrent to a 12-and-a-half-year federal sentence he was already serving. Over defense counsel's objection, the Garcia-Magbanua cases were consolidated, and they were tried jointly in a jury trial beginning September 26, 19, with Honorable James C. Hankinson, who oversaw the Henry Segura trial. Circuit judge presiding the trial. The state presented evidence, law enforcement, 20, civilian witnesses, 16, alleging that one or more members of the Adelson family in Miami hired Magbanua, who hired Garcia and Rivera to kill Wendi Adelson's ex-husband, Dan Markel, so that Wendi Adelson could get sole custody of their children and move to South Florida. The state's case in chief against Garcia consisted of two witnesses, 5'4" tall Luis Rivera, who identified 6'1" tall Garcia as planner and executioner, and FDLE Robert Yao, who opined that whoever shot Dan Markel was over 6 feet tall. Garcia held the state to its burden of proof by standing moot. Magbanua testified denying any involvement and called 5 defense witnesses. Garcia was found guilty of 1-degree murder and conspiracy to commit 1-degree murder. A mistrial was declared on Magbanua's case when the jury was unable to return a verdict. The jury rejected the death penalty. In Garcia's case, he was sentenced to life plus 30 years imprisonment. Direct appeal, Garcia appealed his convictions to the First District Court of Appeals. He was declared indigent, and Baya Harrison, and the bar number, was appointed to represent Garcia on appeal. Counsel Harrison. On appeal, Counselor Harrison presented 2 issues for review. August 23, 21. Garcia timely noticed Counsel Harrison of his desire and intent to pursue all plenary review available to him as a matter of right. Exhibit A. As evidenced by that letter, Garcia clearly lacked a basic understanding at the various procedures and rules governing certiorari review, such as limitations, notice, and venue. Exhibit A. In a written opinion, the First District affirmed Garcia's convictions on 9/29/2021. See Garcia v. State. Counsel Harrison noticed Garcia of that decision in a letter dated 9/30. That was prompt. On October 29, 2021, that year, 30 days after the district court affirmed Garcia's convictions, Counsel Harrison opined that there was no basis for reconsideration, a rehearing of that decision. On December 5th, 2021, Garcia inquired of Counsel Harrison about certiorari, not the way he had it before, review of his case. Counsel Harrison responded on December 16, 2021, that the time for seeking review had expired. In the interim, on December 19, 2021, Garcia again inquired about certiorari review. I think it's certiorari. No notice to invoke discretionary jurisdiction of the Supreme Court was ever filed with the First District Court of Appeal. The time for filing said notice expired on Friday, 30 days, October 29, 2021. Relief sought. The relief sought by this petition includes an order directing responsive pleading on the merits by the state, an order appointing a commissioner, special master, to conduct a hearing and issue a report and recommendation, an order appointing counsel for the hearing, an order adjudicating the petition on its merits. I'm sorry I'm turning my head, but I can't. I got to be able to read. It's too hard to read through the screen. Any other relief this court deems just and proper. Grounds for relief. Petitioner was denied his right to plenary review of the First District Court's written decision opinion by the Florida Supreme Court due to ineffective assistance of appointed counsel on direct review, contrary to Florida Constitution, and he lists it, and the United States Amendments 5, 6, and 14. Standard of review. The right to counsel is the right to the effective assistance of counsel and is made applicable to a criminal defendant via the Florida and the U.S. Constitution, Gideon v. Wainwright. Like claims of ineffective assistance of trial counsel, claims of ineffective assistance of appellate counsel are assessed for deficient performance and prejudice pursuant to Strickland v. Washington, see Evitz v. Lucy, Smith v. Robbins, see Sims v. State. These are all the cases that he's referring to. To prevail on a claim of ineffective assistance of counsel, a claimant must identify specific errors or omissions which demonstrate that counsel was not functioning as the competent counsel guaranteed by the state federal constitutions, and that but for counsel's errors or omission, the result of the proceeding would have been different. Strickland, Evitz, Smith, Supra, argument on the merits. As evidenced by accompanying Exhibit A through G, the petitioner timely noticed Counsel Harrison of his desire and intent to pursue all plenary review available to him as a matter of right. Harrison failed in his duty as advocate to timely file a notice or timely advise Garcia that, pursuant to Florida R, a notice must be filed on or before October 29, 2021. Similar failures have been held to constitute actionable, ineffective assistance of counsel warranting belated discretionary review. Conclusion. Wherefore, based on the foregoing facts, arguments, and authorities, this court should grant the relief requested herein. It is so prayed. Respectfully submitted. Oath. And then he signed his own oath. Certificate of service, did all that, signed it there. Unfortunately, we have the same signature. Doesn't look good for me, does it? The appendix, here's his appendix. See if this is worth reading. Exhibits. Oh, this is his exhibits. Correspondence dated. His letter. This was when he was in Baya Harrison is in Monticello. I think he's writing on the front and back page. That's why it's like that. Yeah, he's writing on the front and back. Now, I would have also liked to know what you argued in your answer to the state's reply brief. If you will send me a copy of it. Lastly, I want you to file a searcher. He's got this spelled wrong. After the judgment of the DCA or Supreme Court, this is vital so that I can preserve my federal habeas. Again, I want to thank you for your time and consideration. I look forward to hearing from you. Thank you for taking the time to read this letter. I hope you're doing well. I'm reaching out to you so that I can request an update on the status of my direct appeal. I also would like to know if you've amended the case within the cause. I informed you of which to be clear. So he did what he was supposed to do. And then there's the response, September 30. Dear Sigfredo, I regret to report that the first DCA, which is District Court of Appeal, has affirmed your judgment and sentence. Unfortunately, the evidence that gets you a trial was very strong. I know you do not agree with that. And the alleged judicial errors were not that strong and rejected by the appellate court. You've had a chance to help yourself, but you have repeatedly rejected it. As an attorney, I have to tell you straight that the truth is that years from now, you will wake up and realize you threw away the key. I wish to God I know what that meant. You have had a chance to help yourself, but you have repeatedly rejected it. As an attorney, I have to tell it to you straight. And the truth is that years from now, you will wake up and realize that you threw away the key. Dear Mr. Harrison, I recently received your letter informing me that the DCA has affirmed my judgment. I am greatly disappointed. The grounds that I gave you were beyond sufficient enough as errors to reward me a new trial. That leads me to the conclusion after reading your briefs that you did not present or argue them effectively. It is too late now to change counsel, but there is the matter of the conflict that I would like to clear up. I brought it up in my previous letter, but have not gotten a response. I know that your responsibilities as my attorney are probably over or close to it, but this is a serious matter. The fact that you represented an inmate at the time that is a witness against my case. Who did he represent? Is a direct conflict of interest. She was an inmate at the Leon County Jail and was deposed on the information she claimed to have, in which you represented her and fought to get her a plea deal for her testimony. Is that Catherine? For that reason, you claim to know inside information on my case that is also the reason why you were ineffective in your duties as my direct appellate attorney. Now, my question is, was it not your direct responsibility to inform the offices of conflict? Why did you not? Since this is such a serious matter, if I do not hear a response soon in regards to this, I will take my concern to the bar and see if they can provide answers. I have kept every correspondence between us, and in them there are plenty claiming you know what's really happened. In closing, I have asked you to this in other letters, various times, but it's apparent that justice on my behalf is not your top priority, so I will repeat my other requests. Please file a certiorari on my behalf. I look forward to an explanation. Who is Robert Charlie Lee? Was he working on my behalf or the state's? Who is Robert Charlie Lee? Who is Robert Charlie Lee? Sorry, I got to save this. Then the next letter is from Harrison, his attorney, appellate attorney. I have your most recent letter in which you confirm that you received my letter of 9/30 informing you, this is October 29th, there was no basis for consideration. Your statement to the effect that there was not enough evidence to convict you is clear contradiction of the record. The murder was poorly carried out. This was his attorney. Leaving evidence of your direct involvement apparent to any reasonable person. Your insistence that there were other valid appellate issues to raise on direct appeal is without merit. We looked at everything. Your suggestion, Amy Mankin. Your suggestion, I had a conflict of interest because at some point in time I represented Amy Manka, is also meritless. Except, is it? Of course, you are more than free to raise any issues in post-conviction claim of ineffective assistance of counsel against me. There's no factual or legal basis. witness against my case, Amy Manka. I will agree with you that I've been wasting my time offering you what I believe is some possible relief from your life sentence, but you would have to tell the whole truth about what you obviously know, especially as it relates to these people down south who initiated this horrible crime. But you've been had by these people, and there is little else to say. Mr. Harrison, thank you for taking the time and the effort to read and respond to this. I'm writing this inquiry in regards to my certiorari. I have made several requests. This was written 12/6. Asking that you file my certiorari, but have yet to receive a response from you. This is a very important part of my due process as I continue to seek relief, exhausting all state remedies, as is my right. I understand we have a 90-day period to file the certiorari. We are still within that window, but are drawing near the end. If you have not filed as of yet, I firmly request that you do so immediately. All I ask is that you fulfill your duty as my court-appointed advocate. Thank you in advance, and I look forward to hearing you. December 16th. Before you could seek certiorari of the Supreme Court, you would have to have had to seek discretionary review, and that time has expired. As a result, your direct appeal is over, and you should move on to collateral attack. I did not see a basis for seeking further review in the Supreme Court because both of the issues raised in the appeal were rejected for lack of preservation, not on the merits. Simply put, your trial attorney did not take the necessary steps to preserve those issues for review, even though those were the only issues I saw the potential merit in light of the strength of the evidence against you. I tried to raise them as a fundamental error, but there is a much higher standard to meet. That's why they throw out objections. There was simply no basis for me to challenge the First District's finding that the issues were not preserved for appeal by your trial attorney. If you choose, you can litigate the preservation issue in the trial court in a motion for post-conviction relief. I still have the thumbnail drive containing your records. Please let me know where to send it. I understand that you no longer believe in the following instructions of the law. This must be the case since you knowingly accepted my case, even though you represented Amy Manka, witness that received a plea deal that was court-ordinated by you to testify against my case at trial. So even if you claim in your letter that my complaint has no merit, it is still my hope that by filing it with the Florida bar, they can somehow deter you from conducting yourself in a negligent and reckless behavior. Now, you say in your argument that is not your responsibility to print onto paper my voluminous records of appeal. You are correct. But it is also not your responsibility to copy it onto a thumb drive. At this point, it is obvious that I do not trust you. That being said, I need you to send me the original records of appeal. The same way they were sent to you by the clerks is the same way I want them sent to me, which in case it is not clear, it is your responsibility. I need those requests now. You might say that is not a fair request, but please understand this. You wrote me a letter that I received on 9/30/21, informing me of the decision of the DCA of my case. It has been almost 3 months. The fact that you're holding on to the records of appeal for so long, even though we had a clear understanding that you would send them to me as soon as you were done, so you are now displaying either a disregard of your duties with absolute negligence, or you are aware of your duty, but are exercising a malicious intent towards me for reasons unknown. Let me, with your experience and knowledge, should know, let me bring to the attention something that an attorney with your experience and knowledge should know. I am given a 12-month period of time after the decision on a direct appeal to file a federal habeas corpus, which can be paused by filing my 3.850, which has a 24-month time frame, or better yet, a restriction. In order to file either, I need my records of appeal. By holding the records of appeal, you have held me back in my post-conviction process by a quarter of the allowed time, which is pretty significant. I have been in the same place for over a year. Why haven't you sent them? So send me my records in their original form. I have also been requesting that you file the certiorari and have not gotten a response to many requests on the matter. We have until 28 of this month to do so. Certification. Holy shit. Who's Amy Manka? Does anyone remember that? Does anyone remember her? Letter case. They received response. Petitioner has filed a petition for belated review. They were hereby file responses to the petition before January 10th. Petitioner may file a reply under the responses on before the 23rd. Such reply if filed shall be under oath. Appellate counsel's response. Comes now attorney Bia Harrison, former appellate counsel for Sigfredo. Undersigned counsel represented Garcia on direct appeal. Evidence of the guilt presented at trial was substantial. Garcia and his co-defendant drove from Miami to Tallahassee to commit a murder for hire in a Prius that Garcia rented and put his thumbprint on the rental contract. He then damaged the vehicle by firing his weapon into the floorboard. Garcia carried and used his cellular telephone throughout the journey, leaving pings on cell phone towers all the way to Tallahassee and back. Tolls were paid electronically using the account linked to the Prius. Surveillance video showed the Prius following the victim to the gym and waiting in a parking lot while he worked out, and then following out of the parking lot. The victim was then shot in the driveway in broad daylight. It was in the garage. A neighbor heard the shots and saw the Prius driving away. The co-defendant testified against Garcia and identified him as the shooter. Garcia then made expensive purchases with the proceeds. Counsel reviewed the record on appeal, filed an initial brief that raised two claims. One was inadequate response to a discovery violation based on an expert witness changing his opinion after being deposed. This issue required a showing of procedural prejudice independent of the strength of the evidence. The second issue was a claim that the trial judge erroneously instructed the jury in response to a question during deliberations about the theory. The state argued that the discovery violation was not preserved for appeal by a timely objection when it was first discovered. Counsel filed a reply brief and admitted the existence of adverse authority, but attempted to distinguish the state's case from their facts. The First District Court of Appeal issued a published opinion affirming this issue. The court agreed that the trial counsel failed to timely raise the discovery violation when it was first discovered, and instead waited until the witness took the stand. As to the second issue, the court affirmed based on a finding that trial counsel gave his assent to the judge's proposed response to a jury question, waiving the issue. Counsel wrote to Mr. Garcia, informed of the appellate court's decision, and advised that he would not be seeking further review. Counsel wrote to Garcia, informed Garcia of the decision, and he advised Garcia he would not be seeking further review, but I don't think that's how it goes. Garcia filed the instant petition on belated discretionary review. The court entered an order directing both the state and counsel to respond. This is his response. The petition is untimely and illegal and legally insufficient, as Garcia readily concedes. Counsel promptly informed him of the district's court decision by 9/30/2020 and advised him that the counsel would not be seeking further reconsideration of the decision. Garcia's letters reveal he was aware of his right to seek further review of his conviction by various means, yet he waited more than 3 years. Well, I don't know that that's the case, but a petition for belated discretionary review must not be filed more than 2 years after. In no case may a petition for belated discretionary review be filed more than 4 years after. The petition does not allege any basis for seeking belated review more than 2 years. Garcia was informed of the decision. The counsel was not filing for further review, and Garcia has not alleged that he was otherwise prevented from filing his own and had exercised reasonable diligence. The petition should therefore be dismissed. Contrary to Rule 9.141, the petition also fails to allege any legal basis for invoking the discretionary review jurisdiction of the courts based on interdistrict conflict or any other basis for jurisdiction contained. Neither the petition nor the appendix contains a copy of the First District's opinion as required by rule, nor does it allege that the appellate court certified any question for further review. Therefore, the petition is legally insufficient and fails to properly invoke the discretionary review jurisdiction of the court. Garcia mailed his petition from Bonifay in November 2024. However, the Florida Department of Corrections is now at Santa Rosa, Milton. See what this one is, if it's the same thing. It's the same thing. State's response. Here's the state. Who wrote this? Oh, Robert Charles Lee is the Assistant Attorney General. He asked who that was. The court ordered the state to respond to Sigfredo petition for belated review by January 10th. A jury convicted Garcia of murdering Daniel Markel. Garcia received a sentence of life in prison. The First District Court of Appeal, so he's just confirming it. Garcia's petitions claim he had a right to petition this court for discretionary review of the first DCA's opinion, but the Florida Constitution makes clear that a discretionary review is not a right. Also, Garcia's petition offers no basis for invoking the court's discretionary jurisdiction, which can only stem from a court of appeal opinion that expressly declares a state statute or that expressly construes a provision of the state or federal constitution, or that expressly affects a class of constitutional or state officers, or that expressly directs conflicts with the decision of another district court of appeal or the Supreme Court of the same question of law. He fails to state that Harrison misadvised the petitioner as to the opportunity, fails to identify the circumstances that were beyond the petitioner's control and otherwise interfered with the petitioner's ability to file a timely notice to invoke, fails to identify the basis of invoking discretionary review. Finally, Garcia's petition for discretionary review is untimely. The rule provides that a petition for belated appeal may not be filed more than 2 years ago. It's the same thing. Conclusion, Garcia screwed up. That is the conclusion. Oh, here it was. It was denied. This was just today. That's why it was closed. How timely is that? Because when I looked at it this morning, it said open. The petition for belated discretionary review is hereby denied, dated today, suggesting that counsel's obligations during the direct appeal process do not extend to the filing notice to invoke. Otherwise, suggests the criminal defendants have the right to the effective assistance of counsel in seeking discretionary review. So the state of Florida doesn't have to pay for that. So when I looked at this, it was open, and that's incredible that I found that today. Denied. Denied. Reality. I don't know what you're talking about. Go up. So anyway, interesting. He was denied, which I guess is a good thing for the family. Who was Amy Manka? Does anyone remember her? Does anyone remember Amy? Oh, yeah. Wendi has like 15 weeks in my guesstimation. Murder by Maestro says if they get a guilty on Donna, Wendy's next. If others think stay as they are. No, she's done. I think Thank you for that. I was reading, so I didn't see it. I think Wendy's done. If how Judge Everett wrote that denial, she's done. If Wendi gets to just sashay through her life without being made to pay for her murderous deeds is a hideous thought. I don't think so anymore. I think she's done. The way Judge Everett wrote that denial of bond and the suppression of the phone call was so strong. I mean, strong. Like, laid it out. Boom. Hammer time. She's done. If I were Wendi, I would not be sleeping so comfortable in Austin. It's just me. I really, when I read that, he brought up the going to sleep permanently in nap time. No, she's done. There has to be a lot of evidence, and they just want Mama's conviction. And done. Hi, my dog. Hi to everybody. Sorry, Susan B. I actually planned this a couple hours ago. This is like old times. Patty bring us all the things on the fly. Well, I saw it this morning and it was an open appeal, and then in the evening it was denied. Who knew? Sure, he took that well. Ooh, so now he has. Okay. So now his appeal thing was denied. But now he has a deposition. Not only good for the family, now they can't do the same as they did to Katie on the stand. You have an appeal going right now, don't you? Plus, they can offer more to Sig for some testimony. But remember, the defense is doing a deposition, not the state. So he's not getting anything for this deposition. But who is Amy Manka? I remember her now. She's trash. 4 dogs dead have died in McCullough after allegedly being poisoned as part of a plan to burglarize 2 homes at McCullough Station. Trash. We don't get the booking report anymore where we get to see everybody. Narcotic, drug possession. Amy Manka. Here she is. It's going to look a lot like the people that were same old meth head looking thing. Nasty. He is now back to facing life without parole. They can dangle something small in his face. Who, the state? John says Amy's the one they call lizard or bug. Trash hole, that's what I call him. No time for it. I hate meth. I hate everything it's done to people. This is a letter from Sig that I wrote. Yeah, it was his appeal. But I wonder if he filed something with the bar. Hold on. I bet he did. I bet they did and they didn't do anything. Florida bar. Ooh, the disciplinary actions are out. Let me see if anyone good is in there. Hold on. Disbarred. Oh man, one day I just got to read the disciplinary actions. This is incredible. People are such trash. They're making up. This one chick made up, what's it say? Povolatus, something her name is, concealed her neglect of a client's civil case by paying him what she falsely claimed were his settlement funds from her personal checking account. In fact, there was no settlement because she never filed the case. And then she made misrepresentations to the bar like no one's going to notice. about the non-existent settlement. In second case, she was arrested for driving DUI. All these alcoholics. She was disbarred. She failed to respond to the bar's investigative inquiries. What's his face isn't in here. One, disbarred. He was only admitted in 2020. Oh my God. He didn't do his CEUs. He didn't do his continuing ed. Nobody here in town, though, so no. Rashbaum's still safe. Siegfried was never going to give anything up when he had a chance of appeal. Now, if to offer a comfy prison, for example, he might talk. He's so violent, though. Like, if he were a good prisoner, then I would agree with you. But he's so violent that he's not getting anything. They can't put him in a cushy prison. He's too mean. He's trying to poke people's eyeballs out and escape. He has so many, I don't know what you call them, like demerits that you can't do it. Yeah, he has too many disciplines. What a bunch of dumbasses. Like, who gets their license in 2020 and then just doesn't do what they're supposed to do? Can I share the podcast? Not today. I can share a link to it if that's what you mean, but I'm not going to talk through it right now. But I can do it over the weekend. I can share it. Where is it? I have to get to the link, but not right now. I can't. But I can put a link up in a minute. I just have too many tabs open, and then I can do it. That's why they wanted them to pose. Well, I'm pretty sure Katie has been strangled. We haven't heard that. We haven't heard anything about her. If Charlie talks and rats on Wendi, could he make a deal and get less time? No. And the reason being, remember, it's what I've been told, because I'm not an attorney or a judge, but what I've been told by attorneys is he took the stand. So because he took the stand, if he comes back and says something else, then who can believe him? He's not getting a deal for talking. I think Charlie will rat, not for any time, just to get that bitch behind bars. Yeah, if anything, he'll go against Wendi. I don't know that Donna will, but that Jackie Fulford standing up there all but screaming about how she wasn't the one who shot Dan Markel. She wasn't the one who planned it. She wasn't the one who paid for it. Like, it was all about Charlie. And I was like, but remember, if Charlie gives up Wendi, he would have to give up Donna and Harvey too. No, he doesn't. He could say, no, not at all. It's the opposite. He could say, my mother had nothing to do with this. I thought it up. It was my money. Mom just came for a visit and it was bad timing. She didn't do anything. She's just protecting me. And she was just protecting Wendi. But Wendi and I thought it up all by ourselves. I don't think so. We did this for Wendi, period. That's all Charlie has to say. I did this for Wendi. I was the brother. I'm the one with the text messages. I did it. But he would have to admit he did it. And we're talking to a bunch of psychopaths. So I don't think he could do it. Yep. Charlie can keep the old story and the state can work with that. Easy money. But if he's not going to turn on his mother. He's going to make sure his mother's safe, which is, I think, one reason why he got rid of Rashbaum. He was too happy to get rid of Rashbaum. So I think that's one reason why he wanted to do that, because he knew Rashbaum sucked as bad as we all know. He's not going to have a choice but to look at his mom while testifying. He can't plead the fifth. All the more reason to not give up your mom and give up your sister, who you now despise because she won't talk to your mom. She won't do anything. And now he knows that she was stupid enough to really drive down Truscott. because that was new information to him. He was like, she really drove down Truscott. They had convinced him she didn't drive down Truscott until he heard it and saw it on the graphics. Remember that phone call with Donna? Absolutely convinced him that she did not drive down Truscott. I bet he does go after her. If the state lets Charlie lie, they're putting up perjury. It's not going to happen. I don't understand. They're hoping he contradicts what he said the first time. But all he has to do is say, I was extorted, I had a double extortion, and it was really Wendy's idea to have them murdered. Catherine met Wendi on the beach. They thought about it all the time. Blah, blah, blah. Done deal. If Wendi didn't exist, none of this would happen. And Wendi had to know. They had the lease on the Point Boulevard property. Right? In May. What was it signed in May or March? I know it was an M month. May or March, and he's killed in July. That's where they were, hanging out. Wendi gave up Dan's schedule. Had to be. She knew when he was on and off that plane. Going to New York, seeing Amy. If Charlie comes to the state and says, I want to give up Wendi, but Donna wasn't involved, and the state says, okay, and arrests Wendi and puts Charlie up for the stand, they're supporting perjury. No, they're not. He can say whatever he wants. Perjury isn't even an issue. He's not going to get up there and say Wendi. That means that he gets up on that stand and says Wendi didn't do it. They're supporting perjury. Right? I mean, that's not even making sense to me. He sits up on the chair, gives testimony. He says Wendi doesn't do it. Well, that's supporting perjury too. The state knows Charlie would be lying if he says Donna wasn't involved. That is perjury. Then why put him up on the stand, Yala? Why put anyone on the stand that's already convicted that isn't going to admit their conviction? That's not logical. Yes, it is the state putting him up. The state has a subpoena for Charlie Adelson. The state has a subpoena for Catherine Magbanua. She's already lied a bunch of times on the stand. That we're paying for. We're bringing her here. We're putting her up. I get what you're saying, but I think you need to think about it complete. The state pays for them to come here. The state subpoenas them. The state had proffers, which they know are not fully true by Catherine. They still put her on the stand. That's not supporting perjury. That's watching someone fail forward several times. They know she's lying. They know Catherine's lying. I don't even know. This is Catherine. I don't even know. I don't know how to. I don't know. I'm not sure. I mean, I just can't remember. I can't. That's supporting perjury in your instance then. And unfortunately, courts all over the country do it. They know someone's lying and they put him on the stand anyway. My point is the state can't use Charlie unless he tells. That is the opposite of the truth of what they're going to do. Catherine will never be on the stand then. She's never told the whole truth. Ever. Ever told the whole truth. They don't need the whole truth. They clearly didn't need it with Catherine. They may not even have the whole truth from Lewis. When was the last time that you watched a case where they put a witness on that was part of the defense, like that had been a previous defendant testifying against someone else, where they told the entire truth? It never happens. They're always holding something back. They're always protecting someone, mainly themselves. It just doesn't happen like that. I mean, how many times has Catherine been on the stand? She was on for herself. The time she was on for herself in 2 trials and the next time was different stories. And she's still not telling the whole truth. So Charlie can come up there and say it's extortion again. That's not supporting perjury. He's already said it. Coming up and giving a story to try and protect his mom to get Wendi, just because we know something to be true, it's all about the jury. Good luck on us supporting that. It's just not going to happen. I understand what you're saying, and it's logical to some degree. It just doesn't happen on a regular basis because they can't. You can't control what someone's going to say. You know, they have the proffer from Catherine, but it's not identical to her testimony. I mean, we know that. She's, whoa. So, and they let it go, and they've never been charged with suborning perjury for Catherine. And I still say that Lewis hasn't told everything. He may have told, because he'll still say, like, where's the gun? I don't know. You think he doesn't know where that damn gun is? He knows exactly where he threw that gun away. It was on a bridge. Did you see that drawing of his? He knows where that gun is. He knew where he threw it away. He doesn't want it out of that water for other reasons, not because of this. In your opinion, the state doesn't need Charlie. They want him there, I think, to rebut if the defense claims it wasn't an extortion and she only listened to what Charlie said. What didn't Katie lie about? Yeah. They never charge for perjury. Well, suborning perjury would be on the attorneys. That's what she's saying. That if Georgia and Sarah Catherine bring her up and she doesn't tell the whole truth, but she's never told the whole truth. That's the whole point of them asking her questions so they can watch her lie. They know she's going to lie when she talks. They know Charlie's going to lie, but they're still going to put him on the stand. No, he's going to lie. They're not worried about Charlie. He's already in prison for life. They're worried about her. If Charlie gets up there and says Donna wasn't involved, that's a flat out lie and very different from not giving all the details. But what does Charlie have to lose? Charlie has nothing to lose. They're not promising him anything by bringing him there. He has nothing to lose to lie and protect his mother. Because if you think, I'm not being like you, but if anyone thinks that Charlie is going to give up his mother on that stand, it's never going to happen. Ever, 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 ever happening. It's not happening. That was the only woman who was there for him when he needed it. It's not happening. Yes, Turtle Boy was arrested again. Don't make me laugh. I have a feeling Lewis can read and write. Well, he can read and write in Spanish. He cannot read English. He's fluent in Spanish. That's not the issue. It's English. If Charlie leaves that massive hole in the story, it gets filled by Katie, etc., and the moldy cash. Yeah. But they don't know that. They're criminals. You know what I'm saying? Like, they're going to piece it all together, and they'll piece it all together at the end, and it'll be fine. But I don't think Charlie's going to turn on his mother. If he turns on it, he could sit up there. What are they going to compel him for? Catherine wanted to do the right thing. Charlie can say, I mean, he can't really plead the fifth. Well, he can because he has his appeals going, right? He still has appeals. So he could just say, I'm not talking. Am I wrong about that? Like, can't he just go in and say, I'm not talking? I'm not saying anything. What happens when Donna and Harvey dies? They die. Donna gets picked up and gets cremated and by Harvey or the next of kin, and she gets buried in what is it? The David Cemetery down in Palm Beach or somewhere where her family is. I don't know, but I think they die. I couldn't watch her proffer. Dude, I took that It's on this other computer. That transcript, and tried to take out all the uns and the ums. It's unreadable. What's the general consensus? Oh, let me put it up. Let me put a poll up, John Wesley. Don't know. I know what I think is going to happen, but that. Don't know. I don't. Let me put this poll up. Will Sigfredo Garcia talk at his? Now remember, it's the defense that's calling him for the deposition, not the state. Not the state. So the poll is up. Charlie would need a succinct version of events that involves none of the rest of his family, and that's not possible. It's 100% not possible. Because Charlie didn't talk to Dan. Be honest, Charlie didn't talk to Wendi until this happened. Remember? Like, it wasn't a very often time, that's horrible grammar. Sorry. It wasn't often that Charlie spoke to Wendi. And she admits that on the stand. She says we didn't, he was living his life, going, screwing children over in Thailand and whatever. So they didn't talk a lot. So how's he going to do that? He didn't know Dan's schedule. To me, she's just done. I hope she's watching. You're done. I think he could get away with not involving Donna, but likely not. If anyone, but he cannot not say that Wendi was helpful because of the schedule of Dan. No one else knew it. She's the one who texted Dan and said, "Are you going to be here that weekend? Yes. Can I take the boys swimming? Can I not take the boys swimming? Can I blah, blah, blah?" I was very upset about the swimming. Such a twant. Was he arrested? Yeah, he was arrested. Yeah. Cleaning up money is so funny to me. Yes, Turtle Boy was arrested. There's not a video of it, although I wish there. Well, I mean, I think there is, but I haven't taken the time to watch it. But he was arrested. Is it buffering or for anyone else or just me? I can't say. Do you think he talks? Patty just covered his appeal. It was denied. He has no incentive to talk. He'll hurt Catherine further because she still have appeals. Did I get rid of it? Hold on. Let me look at Catherine's Magbanua party search. I mean, it's going to be denied, but let's pretend. It's still open. Let me show you. Here's Katie. Killer Katie. Sorry, this is up. Oh, I hate when that does that. Anyway, hers is open. Reply brief. Nothing much has happened. Jury trial transcripts, extension, order striking filing. I'll have to look through this, but hers is still open. There you go, Robert Charles Lee again. They can hold him in contempt and give him jail time. Yeah, he is nothing. He doesn't have to talk to anybody. Sigfredo Garcia, as you were discussing, I just saw the numbers up here increase a little bit. So we're talking about Sigfredo Garcia, who was the shooter of Dan Markel. And there you have it. Wesley doesn't talk and they use him he has no clue who hired him. It's going to backfire. Well, he knows Catherine hired him, but he doesn't have to talk. They can't compel him. What's he going to do? Sit there? He's already got prison. That's why Charlie will never give up Wendi, because Wendi will give up Charlie. Wendi will not give up her parents. She can't do it. They can't force Charlie to speak. They can ask him questions, but he can plead. I mean, he could just keep pleading. Wesley says, "Oh, murder, that changes thing." Sigfredo can tell them to eat. Yeah. I'm sorry, it's buffering, Ala. You don't think he'll talk? Well, I did put a poll up if you want to look at it. The only people who may show to Harvey or Donna's funerals are maybe the few loyal friends they have. A lot of people go to funerals you wouldn't expect. Kristen. Typewriter keyboard that lights up. My keyboard lights up when I type. It does light up. He didn't say anything to save himself or Katie. Why would he try to help anyone else at this point? He wanted Katie to save herself. I don't know why he didn't talk. Wendi knew when Dan was at the gym, but they also followed him from the house. Please, hi, Shelly. Please don't forget to hit the like and subscribe. Sigfredo would only talk if he got a deal. He never gets a deal. Wendi an advocate against? Yeah, Wendy's an advocate against human trafficking. I can't figure out where she works, but I will. I'll keep going. I always said Sig will one day take the stand when it suits him because he's an arrogant, selfish, subhuman bag of shite. That would be the only reason he doesn't talk, I guess. Wendi just was, but her Dan was smarter than her and was on to her. And her bullshit, not being kosher during wedding, shitty family. So silly, and her kids will grow up. I know. Katie ruined her appeal when she testified last time. Katie ruined her appeal when she paid for a murder. They wanted a staycation with Jeff rather than go to California, right? Patty, we heard from the OG that that Sig had slashed an inmate in the face. Did his appeal mention that at all? No. In the unredacted video, Lacoste says after saying something to Wendi, she fell on the floor in a fetal position and cried for hours. Nice thing for minors to see. My guess is Wendi needs a horse tranquilizer. She's living her best life in Austin. If Wendi gets arrested, she will sing like a bird. I can't imagine. I still cannot imagine this guy dating this woman for this long and not having questions. I don't know if I admire that about him or I have more disdain about that. How can you be so smart? He's so smart. Not a clue in the world. Absolutely clueless. The hitman knew that unaliving had to happen Friday as Dan was flying out the next day. Only Wendi knew this. Katie didn't care enough for her kids. It feels seemed so bad. Oh, yeah, it was all about the buck. It's so gross. You will be surprised she has no conscience. So bad, though. Why is that staying up? So bad. I don't understand it. He's dumb. He is. So, a gentle reminder we're going to do the Henry Segura case. So Henry Segura, in 2010, he murdered Brandi Peters and her 3 children. He did so in the Saddle Creek Run neighborhood. So when this happened, it was November 20, November, I have it written down. It was Saturday. Brandi was 27. The twin girls were 6, and JaVante was 3. There's 2 different spellings of his name. It says, this is what the police say, and this is the problem that happened in this. Let's see if I can get I don't have a reader here. I wish I had a reader. So when he slaughtered the family, slaughtered, they didn't have any leads. They didn't know who it was. So here's the article from the Tallahassee Democrat. Who wrote this? Amanda Nally. Tallahassee Democrat released the names Sunday of the 4 people found dead inside their home at 908 Saddle Creek Run. The medical examiner's office completed the autopsies. Brandi Peters was 27. Her twin daughters were 6, and the son was 3. That was his biological son. I want to assure the public that they were following up on active leads in this case. We cannot release details as it would adversely affect our ability to solve the crime. Tallahassee Police Department has classified this case as a homicide, and the preliminary investigation indicates that violence did occur inside the home. Tallahassee Police press release said there was no sign of forced entry during the crime, even though there have been burglaries in the area in the recent past. A broken window near the front door was the result of officers forcing entry into the home. An officer was watching the home Sunday. Brandi was a sweet person, a loving, caring mother, said Abdul Howard, her first cousin on her mother's side. She wasn't a troublemaker. She had troubles in her life. She'd been arrested more than once. But I can't see her harming anybody or bringing some kind of attention like this would happen. Peters had run-ins with the law in the past. Howard says Peters was from Tally, and he grew up spending holidays with her. 2 years ago, he got to meet the twins. The girls were something. They were so smart. He also said she loved to do hair, something her mother did. His family, including Peters, had plans to meet in Tampa this Thanksgiving, which was also the birthday of a cousin. I'm truly hurt because I would never ever felt that this would have happened to Brandi or none of my family members. He said funeral preparations have not been made. For neighbors, the feeling of security is fragile. In his dream, Andre Frouse, 10, walked down the street to the house of the 2 little girls he used to play on Go Seek. Safely asleep in his mother's bed along with his brother and sister, his dream quickly turned into a nightmare. I looked up and I was being chased. Fowles, his younger brother and sister, all slept in the mother's bed, frightened and upset because no one knew what was happening in this town. It was bad. I'm telling you, the property values in that neighborhood, it was if Bundy had been there and just slaughtered people. It was bad. Or like Charles Manson. It was so bad. And there was nothing for so long. At the time, it was Police Chief Dennis Jones. They didn't say anything forever. So this is the trial this is the house. Let me show you the house. So the guy who owns this house, he bought it in 2006. He bought it in 2006 and he still owns it. So it didn't really affect him. To get the house away. He's from South Florida, Plantation, I think. But so this is the house. Just a little home. A lot of those homes are rentals in the neighborhood. Some are family occupied. Usually about 1,300 square feet. Great pictures. Drives me crazy. Dude, stop using your phone or get a better phone. I don't know how old these photos were, but he rents it out a lot. The tubs, scene of the crime. That is a home I would never live in. I would never live in that house. Ever. You'd have to Sage Plus. Just can't handle it, you say. Pull it back up because I did that poll. Went away. So Judge Hankinson is the trial judge. He has since passed away. He had Parkinson's. You see it when you watch any of the first trial with Catherine and Sigfredo. He did that, and you see him shaking. Wendi has not changed the boys' names yet. There's nothing in the record. And they're too old for that. His case is where I was introduced to Assassin Dubin. Yeah, they were in the bathtub that I showed you. It's horrible. This is the opening. There's Beloved. They called him Hang'em Hankinson here. He was beloved. Notice the date. They were killed in 2010, and the trial didn't go till 2019, right before the COVID.
Don't want to get into multiple attorneys being involved in one part of the trial. Anybody have any confusion about that?
No, Your Honor.
Do you intend to concede guilt to any criminal charges, Mr. Prince?
No, Your Honor. Well, I should clarify. There was testimony last time about the vehicle being stolen. Obviously, Mr. Segura will plan to acknowledge that again, but
That's not a charged offense.
Yes, correct.
Okay. I assume the parties request the rule of sequestration be invoked.
Yes, sir, with the exception of the victim's sister. I didn't have any objection to her remaining in the courtroom.
Her name, please.
Monica Peters.
What's that?
Monica Peters.
Okay. So she'll be excused from the rule?
Yes, sir.
And Your Honor, one further request is Jason Doolin be able to come in and out when needed for purposes of wrangling the witnesses. He's mainly if he called to do rebuttal purposes.
No problem with that, Mr. Prince?
No, Your Honor.
Okay. What about experts? Are some of the experts going to be allowed in the courtroom?
I think they would be. I don't know when everybody will be getting here, but obviously I don't have a legal basis to object to any expert being present for another expert's testimony that bears on his own testimony or her own testimony.
I mean, I know that's fairly standard, but I think we need to make it a record when one's going to be in the courtroom.
That's what I was going to say, Your Honor. As we go, we'll discuss it with each other, and then we'll make sure the court's aware and put on the record properly.
Okay. Just bring it to my attention so the record's clear. In case there is a dispute about that, I want to make sure we resolve it. So the rule of sequestration has been invoked. Are there any witnesses in the courtroom at this point in time?
They are not from the state, Your Honor. I know we have one outside, and I told them to arrive approximately 9:30. They need to be opening statement.
All right. Well, it'll be counsel's obligation to make their witnesses aware of the rule of sequestration. They need to remain outside the courtroom except while they're testifying. They're not to discuss their testimony with anyone else other than the attorneys. Make sure the witnesses are aware. We've had some problem in the last trial that was not communicated to the witnesses, and that caused some issue. Mr. Fuchs, you need to make sure that your witnesses are advised of that, because that was an issue in the last trial. Some of the witnesses were not informed, and then we had to deal with a little bit of a mess on that, so let's not have to deal with that again, please. I know you've got them scattered around, but you need to make sure they're aware of the rule of sequestration. You had a motion in limine, Mr. Fuchs.
Yes, Your Honor. State would do an oral motion in limine regarding the letters that Brandi Peters had regarding James Santos that were in the house. Last time the state introduced them for the purpose of items that were found in the house. Throughout the course of the testimony and the defense case, they used those letters to assert the truth of the matter asserted, and that they were in fact truthful, that Brandi was in fact involved in narcotics transactions and things along those lines. Based upon that, the state is moving in limine that they are in fact hearsay. They are being utilized for the truth of the matter asserted by defense, and therefore they should not be admitted into evidence as such.
Right, so you're not going to offer them into evidence this time as part of the search?
That is correct, Your Honor.
And this point of fact, I was just going back through my prior rulings on Mr. Santos, the letters, the emails. I haven't really quite finished that, but I did note that there was not a dispute on the letter. Is it one letter or two letters?
There's actually there's multiple letters that were found. I think that, and we ended up putting 2 in last time. I'm sorry.
All right.
Yeah, I think there were 2 last time that were put in, but we won't be putting it. We'll make sure we don't put any of them in.
And I haven't totally finished my review, but it seems like we may be in a different situation if and when Mr. Santos testifies. But it seems to me that they're not admissible until we hear from him, and based on his testimony, they may or may not become relevant. But I'll let you address that, Mr. Prince, if you have a different position.
That's what I was going to say, Your Honor. I was going to just ask that we defer a final ruling on that until we see what Santos says.
All right. So what I'm going to do is I'm going to grant the state's motion in limine without prejudice to renew once we hear the testimony of Mr. Santos or whoever else you think makes them admissible, but I would think that'd be primarily where that testimony might come from, and I can more accurately assess it at that point in time.
Yes, Your Honor. Also, word of caution with the Dela Cruz, he may have relied upon those or in some way utilized those to form his opinion. I want to make sure we don't mention those during the opening statements along those lines until we're sure whether they come in or not.
Well, I think my ruling last time was that Dr. De La Cruz could testify, but he could not testify as the contents or statements by other people. It's not a way to admit hearsay, would seem to be a similar situation. So I would again make that ruling, at least preliminarily, unless and let you be heard outside the presence of the jury if you think that's changed. Mr. Prince?
That's fine, Your Honor. Yes, sir.
Anything else?
No, Your Honor. We do have a couple items we'd ask the court that we can remove so we can repackage them to make it a little quicker for court for trial. Of course, they've been in the custody of the clerks. 103 EEFF, 105A, 107.
Wait a minute, you.
I'm sorry.
Johanna, throw a rock at it. All right, so 3EE, 3FF.
103.
103.
EE and FF.
Okay.
105A.
Okay.
107 and 109.
Okay. And these are items you want released to you so you can package them in a more presentable form.
That's correct, Your Honor.
You have a problem with that, Mr. Prince?
No, Your Honor.
Okay. Madam Clerk, you can release them to, who are they going to be released to?
Jason Newland, Your
All
Honor.
right. You can release those to Mr. Newland. All right. Anything else from the state?
Trying to make sure I do before I say no. Nothing further, Your Honor.
Mr. Prince?
I was just going to ask, Your Honor, that the state refrain from reporting Mr. McElfresh's statistical findings. At this point, the court indicated you need to hear additional testimony about the statistical findings prior to that testimony being admitted. Mr. Pepys did confirm with Mr. McElfresh, I guess as of yesterday, that he used as a population sample for statistical analysis that is applicable for situations with unrelated individuals. It's a frequency of occurrence table for unrelated individuals.
Your Honor, I intend in opening statements to say that Dr. McElfresh found that Henry Segura's DNA at the scene, but not the frequency of occurrence. Based upon the prior court ruling.
Okay.
That'd be fine.
When are we going to take up the statistical issue?
He's traveling up here on Tuesday is the arrangement we're making, so we can do so at that point if you want.
Just want to make sure we can do it at a time when we don't hold the jury up. So we want to do it at the end of the day or before court or something. The end of the day would be better so we don't have time limits. So,
No, we don't fight arrangements yet, so we can.
What's that?
We don't fight arrangements yet.
When do you think he would testify?
I'm anticipating he's going to test on the afternoon, Tuesday afternoon is what I'm hoping, but I don't know how well we're going to get there or not. But
Well, we're going to need to have a hearing before then, so I don't want the jury sitting in the jury room while we have a hearing, so we need to have some time where we can have his testimony before he testifies.
okay, so we'll fly him up on Monday afternoon and have him here for first thing Tuesday morning. That'll work.
I think what would work better would be to have him here Tuesday afternoon and let him testify on Wednesday. I mean, you're talking about this coming Tuesday. We're not going to be having court Friday.
I remember when an L happened.
When's the first time you were?
I'll keep in mind most of it. So whatever you want to do is fine. Most of us, neither one of us, going to be sitting here, so whatever you want to do is fine.
Law. Thus, we have totally separate jobs, and that's one of our fundamental principles of our system of justice. I decide the law, you decide the facts, you apply the facts to the law. I know all of you see trials from time to time on TV, but you probably don't see one from beginning to end, so it might be helpful if you understood the sequence of events. The next thing that will happen is the attorneys will be given an opportunity to make an opening statement. The opening statement gives the attorneys a chance to tell you what they believe the evidence will be presented during the trial. What the lawyers say is not evidence, and you're not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, I will instruct you on the law. The attorneys will then have an opportunity to make their closing arguments. Following the closing arguments by the attorneys and some brief comments by me, you'll retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instructions on the law that I will give you. Until that time, you are not to discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law that I will explain to you. I now instruct you, you are not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do research about the case or look up any information about the case. If you become aware of any violation of these rules at all, notify the court personnel. During the course of the trial, we will take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them that you're on the jury trying the case and ask them to stop. If they persist, leave them at once and immediately report the matter to the bailiff, who will advise me. Internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. If you would like to take notes during the trial, you're free to do so. On the other hand, you're not required to. That is entirely up to you. We've given you a notepad and a pen for your use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom until you start your deliberations. During recesses, if you'll just leave your notes in your seat, the bailiff will ensure they are not tampered with by anyone. After you have completed your deliberations, the bailiff will destroy your notes. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. And you may wonder what I mean by that. We've had a rare instance where some juror decides to kind of act like a court reporter and write down everything that's said by all the witnesses. An important part of your job is to observe the witnesses, decide whether you think they're accurate historians or not. Don't get so buried in note-taking that you lose that function. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. During the trial, you will be permitted to ask questions of witnesses in case you missed something, you did not understand something, or you need to clarify a pertinent issue. The rules of evidence apply regardless of whether a question is asked by the attorneys, by me, or by you. Therefore, there may be a legal reason why I cannot ask your question. If I do not ask your question, you must not hold that against any of the parties, and please do not take it personally. Subject to that understanding, this is how we will proceed. When the attorneys have finished asking their questions, if you have a question, please raise your hand. I try to remember to stop and ask each time, but sometimes in my old age I forget. But we do it at the end of the questioning by the attorneys. We don't do it in the middle of the testimony, but at the end of the questioning, if you have a question, simply raise your hand. I will give you time to write your question on a clean piece of paper, and the bailiff will collect it. We don't do any questions by the jury verbally because I need to meet with the attorneys and discuss the question you've proposed. If I determine that it is a legally appropriate question, I will ask your question, and the attorneys may ask follow-up questions. If your question is not asked, you must not discuss it with other jurors or hold it against either party. The questioning of witnesses is the primary responsibility of the attorneys. You are not obligated to ask any questions, nor encouraged to ask large numbers of questions. However, if it will help your understanding of the case, you may do so. As I indicated, the next thing that's going to happen is the attorneys will be given an opportunity to make an opening statement. As I've also said, what the attorneys say is not evidence, and you should not consider it as such. However, I do encourage you to give them your careful attention. The opening statements are intended to give you an understanding of the evidence that the attorneys expect to present and the issues in the case. We'll start with the state of Florida. Mr. Hughes.
Thank you. Hey, it worked. I'm always surprised when technology actually works the way you want it to. First thing I'd like to do is thank you. I know yesterday I thank you for taking part in the jury selection process. You were in fact now been selected to be the juror in this particular case, State of Florida versus Henry Segura. And I'd like to thank you. You were selected because myself, Mr. Prince, Mr. Segura, and of course the judge all felt you were the best ones to come in and listen to the evidence throughout the course of the trial, testimonial, look at the photographs, unfortunately. Thank you very much. Once again, we cannot do this without you. That being said, why are you here? Ladies and gentlemen, you are here because on November 20th, 2010, law enforcement officers responded to 908 Saddle Creek Run. This is the home of Brandi Peters, their twins, Tamiyah and Taniyah Peters, and her son, JaVante Segura. JaVante Segura also is the son of Henry Segura, the accused in this particular case. What the officers found when they arrived, Brandi Peters brutally shot and beaten. In the bathroom, they found Tamiyah, Taniyah, and JaVante in the bathtub. One of them shot, two of them drowned. And what the evidence is going to show you is that Henry Segura is responsible for the murders. You're going to hear throughout the course of this that he was interviewed by Tallahassee Police Department on 2 different occasions, days apart. First one was to notify them of the death of his son, and the second was follow-up. And what he did is he lied to law enforcement. He said, I was not there, I was at home the entire time. Tallahassee Police Department did their investigation, realized he was lying, called him in for a second interview to clarify. I was at home all the time. Check my cell phone records. They say I was there. But he made a mistake. He thought he could pull one over the eyes of the Tallahassee Police Department. What they did is they found out he had a separate phone number that he didn't tell them about. And what they did when they checked that cell phone record is they determined he was in fact there at the time that Brandi Peters and the kids were killed. And it goes farther from there. So the question is, once we make the determination, what the evidence is going to show you, that Henry Segura had the motive, he had a means, and he had the opportunity to commit these murders, and he did in fact commit them. The next question is, how did we get there?
Somebody, phone going on. Let's not interrupt court, please.
As I said, law enforcement officers responded to the Saddle Creek Run home on November 20th, 2010. This home is located over by the Fairgrounds, Capitol Stadium, Tram Road, Paul Russell Road, South Monroe Street. And there's the 4-point area right here. Law enforcement officers respond, they get a call. It was actually Artron Timmons who went up there first to do a check because his mom calls him and tells him to go look, but they haven't heard anything from Brandi Peters that day. He walks up and sees blood outside the home. Calls law enforcement. Officer Jernigan, Officer Kidd respond first and foremost, and they approach the home. They go into the home, they are able to force entry by breaking a window, and they realized what was happening there. They're later joined by Sean Wyman, Officer Tallahassee Police Department, and they go into the home and they found what you've already seen. What you're going to hear next, of course, is that they withdraw from the house. Once they clear the house, make sure nobody's still alive, make sure nobody's still hiding in the house. They withdraw from the house. They secure the scene. This is the home there on Saddle Creek Run. Secure it with the tape. You can see here the window that they had to break in order to gain entry to the home. And they contact the Criminal Investigative Division of Tallahassee Police Department. Investigator Mark Lewis is assigned to be the primary lead investigator of this case. The lead investigator is kind of like a head coach of a football team, or any other team for that matter. And the fact that he doesn't necessarily do all the investigative aspects of it, but he's kind of the leader of them, and he assigns his assistant coaches, if you will, to do different roles throughout the course of the investigation. You're going to hear that crime scene investigators were called. I know we talked a little bit about CSI shows and stuff like that, but they are, in fact, real-life crime scene investigators. Annie Pressey is the primary investigator for this particular case from crime scene. April DeBrava is another investigator that's assigned to the Criminal Investigative Division. And what her role is to be a liaison between the crime scene investigators as they're processing the entire crime. They, of course, have training to do so. You're going to hear that there's a lot of blood in this. Throughout the entire house, they process the entire house room by room by room. April DeBrava's role is to do a liaison, to look from things from an investigative standpoint as an investigator rather than a crime scene specialist. She also reports back, of course, as I said, she would be one of the assistant coaches for Mark Lewis. And they do, in fact, process the scene. They look for the evidence in the house. They look for evidence around the victims, and, of course, outside the home. And they start asking questions. They start asking questions to the family member. Who does she know? Why is this important? It's important to know who she knows because of the brutality of this. Law enforcement suspects that it's somebody she knew because of the brutality of it. They want to know who she knows, who's possibly responsible, who can give them leads as to who she may have been seen with the night before, things along those lines. They started asking questions about time frames. Again, she's found early in the morning. Time frames, when the last time somebody seen them? When you saw them last, what were they doing? Things along those lines. Gender information, habits. Time to eat. Time kids go to bed. Things along those lines. What they find out is that she does in fact have her cell phone on her all the time, much like most of us do. Has the phone on her all the time, constantly using it. They find out that she was last seen the night before in the early afternoon, early evening hours. That the twins, one of the twins and JaVante actually were seen with Burger King wrappers shortly after they had eaten Burger King, or appeared to be shortly after they had eaten Burger King. They talked to friends, find out when she was last talked to. Last talked to again, late afternoon, early evening hours. Of course, they find out how the bodies were discovered, as I mentioned earlier. Artron's mom calls over there, can't get Brandi to respond. It's out of ordinary because of the fact that she usually responds to her cell phone. And she sends her son over there, at which point he comes back and reports to law enforcement. They find out possible boyfriend she's with. Does she have any boyfriends, family members? And they also find out about the fathers of the children. And when they find out it's the father of the children, for Tamiyah and Taniyah, the twins, is Antonio Anthony. And the father of JaVante Segura is, in fact, Henry Segura. It's obviously important because you got to let them know about what happened. What they also do is they take a look at Brandi's cell phone. Try and see if they can narrow some things down. Who's she been talking to last? They find out around 6:11 to 6:15, it's a call between Brandi and her mom. You get a text from 6:53 from CC Timmons, Artron Timmons' mom, that we just talked about. They also find out that 6:53 text is the last active communication on Brandi's phone. These are terms you're going to start hearing. You're probably going to learn a lot more about cell phones than you ever thought possible. But there's a difference. Active communication is one in which the recipient of the phone, Brandi in this particular case, is sending something out. That is an active communication. It means they're actively participating in the conversation. There are also passive events. Passive events are things that are incoming. Someone calling and leaving a voicemail, calling a text message with no response, things along those lines. And when they find out, of course, is at 6:53 was the last active communication. At 7:13 is a passive event, incoming. 7:49, another passive event. And finally, at 8:21, a routed event. And what you're going to learn is a routed event is one that happens when the phone is shut down, when it can't communicate with a tower. Battery removed, turned off, something along those lines. And that 8:21, the phone has been powered down at 8:21 and never heard from again. And you're going to see an analysis of Brandi's phone. And this here, whoops. And this is that, in fact, analysis. And what you can see here is we're enlarging the time frame, and it starts 1 week prior to the homicide. And these are all the communications that she has during that course of that week. Both active and passive. So you can see it's in constant use. Look at the time frame. Every couple of seconds, every couple of minutes, she's using that phone constantly. She's on it constantly. Now, each one of these lines are going to be later explained to you what they all mean by Chris Corbett, who's going to explain what each one of these lines are. But right here, what we're talking about is the time and date. And that's it. It just stops. And it stops, and it's never heard from again at 8:21. Well, that asks and begs the question, why did it stop? Why is that 6:53 the last active communication? Is that the time period in which the murder occurred? You're, of course, going to hear that there was an autopsy conducted. Autopsy in both Brandi and the children. And you're going to find and hear that there was food that was found in the stomach of Tamiyah and Taniyah. You're going to hear from Dr. Flanagan, who was the autopsy medical examiner, about the time frames that were involved. And it would be a couple of hours, if you roughly. Can't hammer down an exact time. Again, this isn't CSI TV. But the general idea would be within a couple of hours of their death, they'd eat. Again, you go back to Artron Timmons' testimony about the fact that he last saw them eating Burger King in the late afternoon or early evening hours of that 19th. And that is, in fact, consistent with the Brandi's phone becoming inactive at that time period. In addition to that, you'll see photographs in the crime scene. There's an open food canister there on the table. Spoon still in it. Again, eating patterns, roughly early evening or late afternoon, early evening. Consistent. So at this point, law enforcement has determined who she knows, who she communicates, who's the father of her children, possibly what time the deaths occurred, and they start looking, trying to figure out who may have possibly had a motive. Law enforcement training experience. Typically, in a crime scene such as this, you're talking about money, love, jealousy, things along those lines. That's usually what you primarily look at first and foremost. Who has the means? Who's got the ability to do this? Because of the crime scene, the brutality of this, who's got the ability to do this with the strength that it would cause? Because you're going to hear from the medical examiner that part of the skull was actually crushed. The bone was crushed. Who's got that kind of strength? Murder weapon. What was the murder weapon? You're going to hear from Florida Department law enforcement analyst Jeff Foggy that in fact what happened here is a .32 caliber pistol, most likely. 32 calibers are interesting. You're going to hear that 32 calibers actually have two different kinds of bullets that go with it. There are 32 caliber long and 32 caliber short. And what you're going to hear is that if somebody puts the wrong ammunition in a different gun, they use, for instance, in this case, a 32 short when it should be a 32 long, the weapon will fire, but it doesn't fire right. In other words, it doesn't gain the velocity that is needed to actually penetrate a skull and do the damage you would normally think of regarding the bullet. Then we go back to Dr. Flanagan's autopsy. And what we find is that that's exactly what happened here. That these bullets that entered Brandi didn't do so with the velocity you normally would expect. They actually didn't penetrate bone in some way, in some instances. What that tells us is that whoever it is may not have known quite how to use a gun properly. Wasn't real familiar with firearms. So the question is murder weapon, who had one? But at the same time, just because you have one doesn't mean you necessarily know how to use it right. Who could that be? Who had the opportunity? Who was there? Who had access to the kids? Who had access to Brandi, to the home? You're going to hear that this was not a forced entry. The door wasn't kicked in. Was kicked in eventually by law enforcement, but when they respond, nobody kicked the door in. Nobody forced their entry. So somebody was led into this home. You can find Henry Segura. Initial interview, notify him because of the child. Look for nonverbal cues, emotional, lack of emotion, deceptions, and of course they apply common sense in conducting these interviews. You can have an opportunity to see it. Henry Segura's told his son is killed. Doesn't show any emotion. And we talked about that in opening statements. Not everybody grieves in the same way. Didn't show any emotions. Again, I was home on the 19th. Was there all night. Wasn't me. Couldn't do it. Told law enforcement to check his phone records. He gives a phone number of 509-4380. That's my phone number. Check it. Phone records say I was home. So the next day, he went in the morning. He went to his friend Silas Thornton's house. When officers asked, he gave a phone number for Silas Thornton, 408-8669. So now there's a investigative team division meeting, and they're talking, and they're sitting around talking. Chris Corbett, you're going to hear from. He's a phone analyst. He's the one that's going to talk to you about what cell phones can and can't do, and how it relates into this particular case. You'll hear a little bit more about that in a second. So as they're sitting around their meeting and they're sharing notes about what they've learned, what he says is that 408-8669 was in contact with Brandi Peters all day long on the 19th. This is the number that Henry Segura says belonged to Silas Thornton. So what does law enforcement do? They go down and interview Silas Thornton. Lives down in the Sop Choppy area, in McCullough County, south of town. And when they interview Silas Thornton, what he says is, yeah, it was my phone. It got damaged at one point. It got wet. I put it in a bag of rice. I was with Henry Segura at the time, and I was working. They're both welders. I was with Henry Segura during the time period. I put it in a bag of rice. It was his suggestion to do so. And he left that phone in Henry Segura's truck. And then from that point on, Henry Segura used that phone. Not Silas Thornton. Henry Segura. Didn't tell law enforcement that back on the 19th or the 20th when he was interviewed. So now we have two phone numbers in play. We have the one that Henry Segura says is mine, the one that he says is Thornton's, that we've now learned is Henry Segura's. And what we find out when we analyze those is with regard to that 408-8669 number. At 11:30 a.m., there's a phone call from that phone to Brandi. But in that phone, for some reason, star 67 was used. Star 67 is the function that you use in order to hide who is calling. But she answered the phone, and they talked for 56 minutes, clearly indicating it's someone she knows and has a conversation with. Consistent, once again, with Henry Segura. Between 118 and 128, series of calls to Brandi. Again, star 67 used for some reason, blocking his caller ID, but she obviously knows him because she talked to him just a little while ago on that same phone number. $213, another phone call. 2 minutes, 35 seconds. Again, star 67 used, trying to hide it. Deception. At 2:19, so again, 2:13, almost 3 minutes on a phone call. Right afterward, at 2:19, she sends a text number to 509-4380. This is the phone number that Henry Segura says was mine. What is that? The evidence shows in this particular case that this phone number, this phone call at 2:13, from the phone number that Henry Segura says wasn't his, it was Silas Thornton's, that he was keeping secret, that he kept using star 67 on to hide his identity and that phone number. She sends a text to his regular number and said, "You hang up on me?" Tells you that phone call was Henry Segura, and that she then used his normal number to question about why he hung up. He hung up on me? What does that tell you? 219, they fighting? On the day of the murder? Shortly thereafter, there's another phone call from 408-869 to Brandi, where he uses star 67 again. Again, hiding it. Once again, that's a phone number that Henry Segura gave to law enforcement as Silas Thornton's phone number. But law enforcement investigates further. And they find multiple friends, Silas Thornton, Tyra Wilcoxon, and Miss Hawthorne Smith, that all say, I communicate with Henry Segura on that phone number around the times of the murder, those dates surrounding the murder. So they have independent confirmation from not only Silas Thornton, but also other friends and girlfriends of Henry Segura that is in fact the number that he utilizes, that 408-8669 number that he says wasn't mine. It was Silas Thornton's phone number. Deception. Micro-emotions, deception. So now the next question is, was there motive? We've already seen the 219 phone call or text message, did you hang up on me? So there's some sort of fighting going on between the two of them. Motive usually involves, as I said, money, love, relationship, jealousy, things along those lines. And what we find out is shortly there before this murder occurred, Henry Segura is behind on his child support payments of over $20,000. $20,000, a lot of money. You're also going to hear from a friend of his, lifelong friend of his, who's going to come in and testify. And what he's going to tell you is that he's also a welder at the time. And that they were discussing, he and Henry were talking about getting a job over in Afghanistan. Lots of money to be made over in Afghanistan during this time period, doing welding and things, six-figure jobs. A lot of money to be made. But to go to Afghanistan, you have to have a visa from the United States and Afghanistan to travel to and from. The problem with that is he can't get one if he owes over $2,500 in child support. So it's not only the $20,000 in child support in arrears, but now that child support for JaVante stands in the way of making six-figure salaries and traveling to do so. Is there means? Strength, murder weapon. Does he have one? He's a big guy, a welder. Opportunity to see him here in court, of course. But that's what he does. As a welder, got to move metal around on a regular basis. Big, strong. Does he have the strength to carry it out? Again, as I said, one of these blows crushed the skull. Does he have the strength? I'd say he does. Does he have a gun? Again, had lifelong friend, Mr. Moore. Mr. Moore's former military. He knows about guns through both military and personal. And what he's going to say is, prior to the murders, I saw Henry Segura with a .32 in his car. Again, .32 is the kind of weapon that was shot, that Brandi was shot with. Milo shot with. You're also going to hear that he asked his girlfriend and told her, I need a throwdown gun, just before the murders. Law enforcement explained what throwdown gun is. Throwdown gun is one that you can just throw down and it's not traceable back to you. She didn't supply it, but that's what he requested and talked to her about doing. Why? So we know he got the motive. We know he's got the means to the gun, the strength, asking for a throwdown gun. But does he have the opportunity? Remember, does he have access to the kids? Who was there? Was he actually at the home? He says, I was home all day. Check my phone records. Well, access to the home He's not heavily involved with the kids, but he does know them and was at one point. They know him. Obviously behind on child support. House was not broken into. Door wasn't kicked in. Does he have the access to the home where somebody would let him in? Got communication with Brandi all day? I would submit, yes. He would have access to the home in that manner. We also go back to cell phone records. Once again, they compare the phone records for Brandi, but now they're also looking at the undisclosed phone, as we call it. This is the phone number, that 8669, that Henry Segura elected not to tell law enforcement officers when he was told about the death of his son, and then go to law enforcement officers. Both phones are inactive between 6:53 and 7:23. And if you go back and you think about the times of the death that we previously talked about, the inactiveness of her phones, that long list of scrolling ended at 8:21 with the last text message that she sent out prior to that. Brandi's continually remains inactive, never returns. 2 short data sessions, and your data sessions are internet type access, your phone, but that doesn't mean you're actually searching the internet. Your phone can auto refresh certain internet things that you have. Say CNN pulled up on your phone and you aren't using your phone, it still may refresh, even though you're not actually having it in your hand. Those are what data sessions are. So there's data sessions at 7:23, and then a text is sent at 7:37. And both phones, again, are inactive from 7:37 to 8:21. And at 8:21, that's the time period that we know that last call went out of that last time that we know Brandi's phone is powered down at 8:21. At 8:21, exact same time period, exact same time, Henry Segura makes a 2-second call, immediate disconnect. No connection. 1-1000, 2-1000, butt dial. Now, this is where cell phone stuff gets even more interesting. When you're talking about cell phone, there are certain things called RTT. What is a time calculation, time distance calculation? And the way that cell phones are structured, that the signal that your cell phone gets takes a certain amount of time from getting from one to the tower to your cell phone and back. That's your time distance calculation does. It doesn't give you an exact GPS coordinate back then. Keep in mind, we're talking about 2000. We're not talking about today. Phones are a little bit different now than they were then. It doesn't give you an exact GPS coordinate, but it does give you distance from the tower. So if you know the location of the tower, if you know the distance, you can create kind of a little arc, or at least the general area you're talking about there. And if you know where all these towers are, you can plot it out. You can actually go down even further. Each tower has got a section, 3 different sections to them. And they go out and they're roughly a third, but they're not always exactly a third. So it's kind of divided up into 3 pieces of a pie, if you will. And that can narrow it down in that particular direction that the phone was communicating. If it was on this particular sector off this particular tower, we know it's going to be roughly in that 3rd quadrant in that general direction. And you can kind of get an idea of where phones are during that time period and using this database. So law enforcement can go back and do exactly what Henry Segura said to do. Go back, check my phone records. It shows I'm home. 509-4380. And the phone was exactly where he said it was. It was at his home. The only problem was everything was inactive. Everything was passive. There's nothing outgoing. The phone was there, but was Henry Segura? So now we go back and we take a look at this 408-8669 number, the one that he says belongs to Silas Thornton, not my phone number. And you take a look at that particular phone number, which we now know to be Henry Segura's. And when you plot those sectors and time distance calculation, the rough sector right there, there's our Saddle Creek Run with the arcs. Those are the communications between 6 o'clock and 8:21, November 19th, 2010, at the time of the murder from that phone number. But we're not done. What law enforcement then do is they go out and they get with Silas Thornton, and they have Silas Thornton go with them, and they purchase the exact same phone that Silas Thornton said was his that now belongs to Henry Segura, that 8669. And they take that exact same phone, they hook it up to the exact same carrier, and they run a series of tests. They run phone calls, they run text messaging, and they run data access. Almost 100 of them are amassed during this time period. Okay? They stand inside Brandi Peters' home. They stand inside the living room where the murder occurred. You go to his house, Henry Segura's house. And they go back and they plot it, just like they did for that 8669 phone number. And when they plot all the data that they utilized, looks familiar. It was exactly the same. They did this from her living room, and this is the data that they got, and that's the data from that 8669 phone number. What we know, Henry Segura has got the motive, he's got the means, and he's got the opportunity for this murder. We're not done. You're going to hear from Dr. Kevin McInfresh. Dr. McInfresh has got a long history of analyzing and interpreting DNA over 30 years. He does analysis on, quite frankly, mass type stuff. So he's looking at very low frequency or very low amounts of DNA and making determinations. In fact, he even does testimony, or he does stuff for Department of Defense with Whom the Unknown Soldier. He had a hand in the analysis of September 11th. He had an analysis of Indonesia and identifying the victims of those particular events. And he goes back and he makes an analysis. And he is asked to take a look at a grab bar, a DNA swab from a grab bar that is right there in the bathtub, right above where the children are found. And what he finds is a mixture containing Henry Segura's DNA. Ladies and gentlemen, when you put together the motive, the means, the deception, the opportunity, the DNA, you're left with one conclusion: that Henry Segura committed this particular murder and is responsible for the murder of Brandi Peters, Tamiyah and Taniyah Peters, and JaVante Segura. Thank you.
Well, we take 10 minutes. We'll let Jerry step out. Either side need anything?
No, Your Honor.
All right, we'll take 10 minutes.
I kind of wish we didn't have the court system that we had. Put them out of our misery. We need the Wild West to come back. This is ridiculous.
Court is back in session. Please.
You have an issue, Mr. Brent?
Yes, sir.
Everybody be seated.
I was just trying to do a last minute double check regarding Santos. I'm going to be general with reference to him, but I want to make sure that I wasn't going to cross into anything that the court had previously prohibited. My transcript that I was trying to check cut off prior to the court's ruling. So basically what I intended to say is that he's a drug trafficker. At some point he recruited Brandi to mule cocaine for him. He became aware that she was basically skimming drugs, and when she refused to pay back for the drugs that she had stolen, that he had a bill. That's what I.
Right. Does somebody have a page number where my ruling is? I would like to reread that, but I know, what's that?
Yeah, I don't have it right here.
It's got to be right after page 87. That's where the testimony.
Which volume?
This is a motion hearing excerpt from August 2nd, 2017.
August 2nd, 2017, after page what?
After page 87.
Okay. All right, I'll look at that, but I don't need it this instance, but I mean, I recall my ruling. I wanted to look at it a little more specifically, but that doesn't cross the line. We ready for a jury?
Yes, sir. No, just for record purposes, the only issue I have with that is we didn't know it comes from Santos, it comes from the police to fit, just before his testimony, that could be problematic, but anyway.
That could happen with anybody's witnesses, including yours. So at this point, he said on the record, he is going to testify. So there's certainly a good faith belief that he's going to. So anyway, I'm not going to prohibit that. All right, let's have a jury, please.
All right.
So someone's asking what's so interesting about this case. Well, this was the last 2019, the last death penalty case that we've had in Leon County, and it ended in a mistrial. Hence my point. Our people are soft on crime. Like, this town is very, 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 very liberal. And in fact, the juror said, let me get to it. What did the juror say? Hold on. The juror said, if there's not a spoken, he said part of the conflict came from a perceived lack of evidence. They had a jury consultant. So it wasn't the juror itself. I'm going to have to go in and look up and see if I know any of the jurors. Jury consultant Alan Turkheimer said that his jury had a lot to consider. With the death penalty on the table and children as victims, people wanted to be sure justice was served. He said part of the conflict could come from the perceived lack of evidence. If there's not a smoking gun, if there's not DNA evidence, doesn't connect, add up to the defendant, some people might have a harder time. Dots that a new jury will have to consider, but the process could be tough. So that's that. I don't know why it's not scrolling up. But, so that's what happened. New trial started in November, and it's still not letting me scroll up. The defense claimed multiple people and a Mexican cartel. The trial began in 2017. Again, it was so long after the crime. Based on autopsy photos in the first trial shown during the first trial, she was shot multiple times. It's very likely that she put up a fight when she was attacked. Evidence inside her house showed there were signs of a struggle, a broken fake nail. That's what's going to happen to me. This is going to be my obituary. A fake plant that fell over and blood splattered all over the foyer. A medical examiner said it's possible Peters was shot 7 or 8 times at close range. 4 bullets were found in her body, in her head, ear, chest, and abdomen. 3 weeks of trial, the first one, consisting of 8 women and 4 men. And they ended in a mistrial. So this is, my point is, why they don't go after the death penalty in this county, because they're not going to get it. They're just not going to get it.
For the jury.
Everybody be seated, please. You may proceed, Mr. Prince.
Thank you.
Good morning again, folks. Again, my name is Nate Prince, and like Mr. Fuchs says, I do want to, before I get into any of the evidence that we're going to talk about over the course of the trial, again, thank you for your time and attention to this matter. Obviously, there's a high-stakes case before you, and it's important to both the state and the defense. And so your careful attention to the specifics of the evidence and the testimony, as well as the arguments by counsel, is always appreciated. Opening statement is, as probably was apparent from Mr. Fuchs' argument to you, kind of our opportunity to give you a preview of what evidence we anticipate introducing during the trial. In addition to that, though, you're going to hear law from the court, which he'll instruct you about. The only thing that I ask you regarding the court's instructions to keep in mind as we go through the process of introducing evidence in this case is that the ultimate question you're going to be answering at the end of the trial is one of evidence. It's one that depends on the state proving beyond and to the exclusion of every reasonable doubt that the defendant is the person who committed this offense. You won't hear any dispute from the defense that this is the most heinous offense that's been committed in Tallahassee. There isn't any argument against that. The problem is that it wasn't Mr. Segura. And I know that because this is a heinous offense, you're going to want to see evidence that not only makes you feel comfortable returning a not guilty verdict, but also puts you at ease with the fact that the state really did fail to meet its burden. And so to that end, I'd like to talk to you a little bit about some of the evidence that you're going to hear from the defense during the case. First and foremost, I want to talk about evidence pertaining to motive. Obviously, if the evidence pertaining to motive doesn't make sense or falls through or is rebutted by other evidence, then that's a problem for the state with its case. Mr. Fuchs told you about, and you will hear evidence and testimony indicating that Mr. Segura had recently had a $20,000 roughly child support judgment placed against him by Ms. Peters, by Brandi Peters, and that there were all kinds of consequences that went along with that. He was subject to being incarcerated. He was subject to having his driver's license suspended. He was subject to having his tax refund seized. He couldn't work internationally, as Mr. Fuchs said. Also, he couldn't get any professional licenses that he held or would have held renewed or granted in the first place, and his wages could have been garnished. What the state didn't know, what law enforcement didn't know when they developed that evidence, was that Mr. Segura was already in that position with someone else. Another child's mother that Mr. Segura had previously, Tamiyah Hawkins, who hates his guts but will testify on his behalf in this case, she had obtained a child support judgment of an almost identical amount some years before this happened, and it was still in place, which is to say he already couldn't travel internationally because Tamiyah Hawkins had a $20,000 judgment against him. He had already dealt with having himself put in jail and getting out by making a partial payment. He had already dealt with having his license suspended and getting it reinstated by making a partial payment. He had already figured out ways to work around having his taxes seized, which is to say that he would work on jobs where he could be paid under the table, and he would work all over the country so that it wasn't easy to find out where he was and seize his assets as they came in. He also, because he wasn't able to get professional licenses, worked jobs that he didn't have to have a professional license for.
Wait, I got to stop this for a minute. I'm going to stop this for a minute. Look here. Look at this. This is Henry Segura's docket. Motion for post-conviction relief. There is an exhibit. Now, he's already been tried twice. Once was the mistrial because, we're weak here. It's crazy land. Trying to close some stuff. It's not opening. Order to show cause. Let me just go down to it here. Slow. Here we go. Order of recusal. Circuit Court Judge Tiffany Baker Carper recused herself. Josh Dubin is assigned. John Fuchs is the assistant state attorney. Holy shizno. This is 1/10/2025. So Judge Neff Lance was assigned. Motion to correct illegal sentence. What in the fuck are they doing? Isn't Josh Dubin that asshole, that Roberta talks about? The Innocence Project? What in the hell is going on in this town? Why would Josh Dubin take this case? Of all cases. Oh, that's right. It's not opening up. It's making my life difficult. I just wanted to get a list of the jurors. Let's see if I can do it again. What in the hell's he doing here? Why is he taking this case? Of all the cases. It's not opening up. I'm going to go out of it and come back in. I can't believe what I'm seeing. I can't believe this didn't make the news. I guess I can. Face it, Patty. Yes, you can. What did the appeals court see? Yeah, that's what I'm saying. Yes, I can. I mean, when I saw a 2025 date, I just wanted to get the jury list. They cannot let this animal out of prison. Joel said he's not covering Karen Reed. This docket is forever long. Just go Control B and see if it'll take me to the bottom. Oh my God. It's forever. Motion. I mean, he's had action in here. Notice, order from the DCA, the court's order motion filed is granted. The court notes that the transcripts were timely received. That's 2020. Mandate affirming lower court decision, appeal recorded. That's 2021. Motion for post-conviction relief. It's not opening up. Of course it's not. If you were in prison, you'd have to have an easy bake oven. It's called a light bulb. You'd have to have a light bulb, Kimber. I guess I just gotta wait till it's open. And close this for now. I can't. I honestly makes me angry. Like it's making me physically sick right now. See if I can finish it later. Why would you do that? Why would you let this man out of prison? Why? Look at it. This is what I'm trying. I'm trying to get one of these motions to open. Motion for leave. Motion for post-conviction relief. Motion to correct illegal sentence pro se. Judge a kind case. Judge added Tiffany Baker. Order of recusal. And then Josh Dubin has this signed. Order of an assignment. Oh my God, it's opening. Praise the Lord. So slow. I'm so sorry. Does anyone remember creepy crawlers? No, I must have missed something. Listening while getting late night snackage. Did you hear what I was saying, Murder? Josh Dubin is working on the Henry Segura case. Did you notice it when you started watching yesterday? I'm trying to get this shit to come up and it's not. I mean, it's slow. It's my freaking Acrobat, super slow. I'm like, my head is spinning right now. I think Wesley put the name in front of John Holmes so he didn't think he was John Holmes. You knew this was in the mix? Oh. I'm trying to bring up the case file and it won't come up. It's just spinning and spinning like my brain right now. How do you not tell me these? Why is Josh Dubin back in town? $47 in snow. Won't open up. I can't get it to open. I don't know why. I'll have to look at it and do it tomorrow. I'm so shocked, though. I had no idea. Hold on. Let's see if I can do. See if there's a press release. Stop it. Some freaking Instagram bullshit. I hate Instagram. Says on November 19, 2010, Brandi and her children were slaughtered. That's what it should say. In their home, JaVante was the son of Henry and Brandi. Henry had no motive, either his son JaVante, Brandi, or Brandi's other children. An incarcerated cartel Affiliate James Carlos Santos confessed under oath to sending a hit squad to carry out the cartel-style killings. From the 200-plus DNA samples collected from the crime scene and tested, Henry Segura was excluded as a DNA match. Imagine spending 13 years of your life locked away, wrongfully convicted, and serving a life sentence. The nightmare became a reality for Henry Segura, an inmate within the Florida State Correctional System, all because the police's relentless determination to close the case. Now it's time to take a stand. Like there's nobody, like some like Asian person is in this. That's it. What in the loyal world are we coming to? Oh, so they show his like high school photo. God. Dear Mr. Mailman, if this letter happens to get us lost, send it to heaven because it's going to an angel. Please sign this petition. Sean Carter Scholars and Dubin Fellows. What in the royal fuck is that? I was going to give up swearing for Lent. All the evidence against Henry is circumstantial. How the hell else is anyone convicted, Matthew? Denver clearly shows how screwed up our justice system is. I saw this case on a show. How did she have those kind of injuries fighting off someone? He did not have a single mark on him, not even 10 hours later. I'm going to puke. This is always their go-to. Tiffany. Where is the DNA? I saw it on a show. As a convicted felon, I know, oh, this must be Sean Carter. I know firsthand how easy it is to become a victim of crime. Oh my God. How many people signed the petition? Does it say? 680 up here. That's it. If you think for one freaking second my face is going on that petition. Our future. Alexis, Aniyah, Jade, Kayla, and Sadie. 7 weeks hands-on fellowship where they participate in creating and amplifying the @Free Henry Segura campaign. The opportunity not only helped our scholars develop their professional skills in 2 words I don't like, but also enabled them to positively impact the lives of others. Post your... No, he doesn't have any comments. That's unbelievable. Oh, it came up. God, that took forever. Comes now petitioner Henry Segura, pro se. So this he was on his own. The defendant has illegally sentenced to indefinite imprisonment. In direct violation of Article 1, Section 17 of the Florida Constitution, the prohibition against certain excessive punishments. The unconstitutionality of Florida's life sentence gives no real meaningful opportunity to be reacclimated back into society, which has created an illegal indefinite term of imprisonment. That's the point. We don't want you. The defendant claims that Florida has abridged its constitutional right to be safeguarded by the excessive punishment of indefinite imprisonment by passing a legal legislative law that violates its own constitution, which is the supremacy law of the land. The state of Florida continues to nullify parts of its constitution in regards to indefinite imprisonment is forbidden, found in Article 1, Section 17. As the Honorable Supreme Court Chief Justice Arthur J. England Jr. so pointedly and righteously declared in his dictum in Alvarez, moreover, if the net effect of a penal statute is to provide an indefinite term of imprisonment, the law is at odds with Article 1. Additionally, by administering indefinite imprisonment in the terms they have defined as life, every single state judiciary has broken the oath that they underwent to become a judiciary when they swore to obey and protect the state of Florida Constitution and the U.S. Constitution. As such, each judiciary that is given an illegal life sentence, indefinite imprisonment, has essentially become a party to the present claim and thus cannot be an overseer of the claim. The defendant will thoroughly depict this court's jurisdictional authority to hear the defendant's claim and in support thereof presents. The historical path of indefinite imprisonment, meaning being placed in prison for the rest of one's life, blah. The legal interpretation that must be applied in determining whether life is in fact violation. What is life, though? Can we call it a retroactive abortion? The United States constitutional right the defendant has in being protected by the guarantees of due process of law, equal protection, and against cruel and unusual punishment. How when a state violates their own state constitution, blah. The United States Constitution guarantees the defendants are protected against cruel, blah. 30 states' total combined amount of life without parole sentences to even come close to Florida's total, they would still fall short by 1,000. The defendant positions that every statute within the state that prescribes a life sentence is unconstitutional, as each life sentence violates 1 Section 17, and by not abiding by its social contract, the people of Florida, it has abridged the defendant's right within the U.S. Constitution that guarantees due process of law, equal protection, and protection against cruel and unusual punishment. Well, there you go, Sigfredo. On September 2011, the appellant was arrested for a quadruple. He did not want to pay child support. It says, the state of Florida claims the appellant killed his son, Brandi, as well as her twin daughters. He didn't want to pay child support. The state claims the appellant's DNA was found at the scene. The state also claims TPD didn't release any info pertaining to this case, so the knowledge of the appellant had of how the kids died had to come from him committing the crime. The state claims the appellant committed these murders on 11/19 and he acted alone. The appellant has documents from the Department of Children and Family where he put himself on child support, but you were behind. In July 17th, the appellant was found not guilty by 11 of the 12 jurors. That resulted in a mistrial. 11 of the 12? The appellant also has multiple corroborating witnesses, that's 1T, dear, whose testimony, along with a massive amount of evidence proving his innocent, FDLE, along with number of outside something. A claim that sentence is illegal can be asserted anytime in a proceeding under 3800A, even if it could be raised earlier, Morby State. Agencies on the defense, it's not offense, as well as the prosecution testified that out of 200 contributions, DNA found at the scene, as well as the murder cleanup scene found at Jack McLean Park, the appellant, which is a nearby city park. The appellant was not a contributor to any of the DNA. The appellant has a sworn affidavit from Margaret Douglas during police interview she had with Tallahassee pertaining to the murders that the judge would not let the defense submit into evidence, stating that she called the appellant and told him the horrible news that his son was murdered. The appellant would also like to state for the record that according to the crime scene medical examiner as well as FDLE, there is multiple evidence proving that more than one person committed this crime. Evidence such as DNA under the nails, in which the ME testified came from a female, as well as the fact that her nails were broken from the struggle she had with her captors. The crime scene analyst testified that there were multiple shoe imprints found in the foyer next to and around the body. There There were also 200 more samples of DNA, which the appellant was not contributor according to the FDLE. It's forbidden to put you in prison for life. The abolishment of slavery in 1863, the old plantation owners or masters literally created a subhuman race called the inmate. In 65, with the 13th Amendment's provision of indentured servitude. In 1868, Florida incorporated a new company known today as the Department of Corrections, and the new way of life began. A new slave market was created, but rather than crop holders, this new system would be shareholders. Any judge who profits off of giving unconstitutional life sentences is no better than the slave masters of old, as it's a modern way to profit off of human life. What better way to ensure one's profit margin and longevity than to create a system that guarantees animals long-lived profits and security? This is not even considering the culminating effect of the self-economic gains that endless line of fatherless children guarantees those who invest, don't murder a whole family. Upon any refusal to find this present claim meritorious, the defendant believes a full investigation into each judge's financial investments is warranted. Let me break this down. And can possibly establish motive for them breaking their oath as a judiciary that was forbidden to give an indefinite term of imprisonment. People of Florida have the right to know where their judges, prosecutors, and even their own attorneys bank on their indefinite imprisonment. History clearly tells the story of why people of Florida chose to add indefinite imprisonment, because we don't want to be around animals, not because the Florida Constitution in 85 was undeniable that it was due to attempts to undermine the will of the people in abolishing slavery. Dude, people were just shooting them at dawn before this. So I don't understand. It was the master's way to reestablish slavery back in the social fabric of society through the penal system. They began arresting and sentencing the now ex-slaves. You weren't a slave. It's not 1863. And if it had been me, you'd have been shot at dawn. The phenomenal shift that the Willie Lynch letter, The Making of a Slave, so candidly pointed out that the slaves would make essentially the tactic that the masters would use. This phenomenal shift took it from about crop holders to being shareholders. Hence the indentured servitude of 1865. If this isn't the biggest freaking stretch of life, it was only 2 years after slavery was abolished when the masters began ensuring their way of life by leasing lifers out under the manipulative law of the 13th Amendment, indentured servitude. 3 years later, they would implement another significant estate within their shift by the Florida Department of Corrections. This backdrop is essential in understanding how in the late 1800s, many judges who were ex-plantation owners held financial instruments in the criminal justice system. The motive on why today's judges ignore such clear constitutional prohibition needs to be identified, and bring in Dubin, of all people. The preamble of the Constitution, which I'm not going to read because this is ridiculous. Motion to correct an illegal sentence. The Supreme Court has acknowledged that a statute being found unconstitutional violated the unconstitutional rights to due process, and anytime a defendant has a substantial and legitimate expectation that he will be deprived of his liberty, a court must exercise its constitutional discretion to obey the dictates of both state and federal constitutions. As such, the citizens of Florida have a constitutional right to be safeguarded from indefinite imprisonment. How about we just give you another 75 years? Can we call it that? The petitioner states that the provisions in the Florida statutes that prescribe a life sentence without parole, old parole system does not meaningfully opportunity for release, and thus that is an indefinite imprisonment, are unconstitutionally and patently fails to comport the oath. It is undisputable by an animal that any state statute exceedingly the constitutional maximum allowed by law is cognizable under motion to correct illegal sentence, it can be ruled on at any time as it is a fatal error on the face of the record and must be ruled on de novo. When a state statute violates a provision on or prohibition within the Constitution, then the essential requirements of law mandates the law must be found unconstitutional and stricken. Plain language. The rule is clear when the court is interpreting statutory law, it must use plain language, must favor the accused. Here in America, in the context of plain language, the word indefinite means unlimited amount of time or measure. And the courts attempt to skirt the issue by the secondary definition of the word indefinite. Life is indefinite enough to explain how long one is in prison until they die is an erroneous ruling that, if not corrected, will create a manifest injustice. It was not mortality that was forbidden, but indefinite imprisonment that is forbidden. Even Florida's Supreme Court has stated indefinite confinement means being placed in confinement for the rest of your natural life. If the jury determines there's a 51% chance the defendant will again commit a burglary or some other such crime, he must remain in hospital indefinitely. Draconian perhaps, but it might well solve a portion of our criminal problems. Judicial estoppel. Putting aside the plain language doctrine, the Supreme Court defining indefinite in this manner, judicial estoppel means must stop, prevents it from changing positions in interpretation as it would make a mockery of the justice system. I think you're pretty much doing that, Segura. Judicial estoppel disallows a court to change positions simply whenever it suits their fancy, and just because it's being used in civil law context. Indefinite confinement. Indefinite confinement runs parallel with indefinite imprisonment as is a mirror image of criminal law's indefinite imprisonment. By the state of Florida defining civil commitment as indeterminate confinement, which can be indefinite, as it has the potential to place you into confinement for the rest of your life, it automatically conceded the same when it came to indefinite imprisonment. This is the proverbial nail in the coffin, and coupled with plain language doctrine, it must be interpreted with the rule of lenity, mandating that any dual definitions must advantage the accused. Unwaveringly, meaning dual meaning word of indefinite has erroneously been applied and has not advantaged the accused. Indefinite, undefined, ambiguous, indefinite, an unlimited time or measure. Only words conjunctively with the second and latter definition of the word excessive punishments automatically disqualifies the word as excessive. Only works conjunctively with the second and latter definition of the word indefinite. The Supreme Court of Florida has denied the claim that life amounts to indefinite by stating life was defining enough. But this absolute misses the mark, says an animal. Plain language uses the second definition of the word indefinite as common usage. Also, there are no different levels to something being ambiguous or undefined. Either something is defined or it is not defined. And there are no levels of excessiveness when it comes to something being defined. To be defined or not is black and white issue. And as there is not any levels of excessiveness, it is clear that the word indefinite, people, can you imagine being in jail with this guy or prison? Petitioner's claim meritorious. Clearly establishes the merit to the defendant's claim to not rule in the accused's favor would seriously damage the integrity of the American judicial system and would suggest to the world that our judiciaries do not have to obey or protect their own constitution. Shall we announce to the world that the leader in democracy, we are a republic, by the way. We are not a democracy. I swear I wish people would stop saying it. The United States of America wishes to admit that we have been preaching to the world is a big illusion. It's an illusion that we're a democracy when we're not. We're a republic. As the Honorable Supreme Court Justice, blah, 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 so pointedly out, righteously declared, here it is again, Ratliff Court erroneously rationale, indefinite imprisonment is to be interpreted as vague imprisonment. Indeterminate sentencing, he's just going on with cases. Oh my God. How long is this? Court has a duty to strike. In conclusion, I want let out. Summary. Notice of appearance. See if I'll open. Oh, it did open. Following attorneys, here it is, Marie Louise, Josh Dubin, and Marie Louise Samuels Palmer. Samuels Palmer Law, Tampa. Notice of appearance, order to show cause. Here's the order to show cause. This cause comes before the court on defendant's motion for post-conviction relief. Ordered and adjudged that the office of the state attorney for the Second Judicial Court shall now show cause within 60 days of the date that this order why a hearing should not be held on the defendant's motion. So that's March 10, 2023. First Amendment rule. I don't know if this is... Who signs this if it's worth? I mean, it's long, which it should be. Oh, it's all about... I'll have to do this tomorrow. I'll have to read this. This is 44 pages. Let me download that. Because I want to see it. Okay, so that's there. Motion for leave to amend rule post-conviction. Here's Josh Dubin's answer. The defendant hereby moves this honorable court to allow him to amend the Florida Rule of Procedure and accept the motion as timely filed. He's an indigent prisoner serving multiple life sentences. Segura timely filed his motion for post-conviction relief. The court entered an order to show cause. The state has not yet responded. Provides the defendant may amend his motion at any time. Segura's case became final for purposes of post-conviction 90 days after, whereas the defendant seeks to amend his motion within the 2-year time frame for filing. Segura is contemporaneously filing with this motion. Segura has been diligently working on the motion and researching his claims. It would be arbitrary denial of due process to refuse to allow him to amend his timely. Then this is the reason, order of recusal for this Timothy, an order of assignment, and I bet it's all going. So then that was assigned to Lance E. Neff, who I don't know who he is. And that's that. That's crazy. Ooh. What you do it, Kimber? You're going to take a photo and send it to me? Okay. Murdered by Maestro Garcia. He called me out on Wendi that came and said they were on a news channel and said that they said their name is, I want to share all of it. Okay. No punishment is what they want. I'm so confused. Why did I think Dubin was from New York? Isn't he from New York? His office is in New York. The Jews were slaves in Egypt for 400 years. There's a, I got to read this. Like, this is, I'm just, of all the cases to take, you take the family annihilator. I don't think I can get past that for a while. I don't know that I'm going to sleep knowing that that fool could be out. I can't imagine that he would win on that. Can you imagine? Can't imagine. I mean, but they're sincere. Like, I can't even believe it. So now all of a sudden, prison is indentured servitude? The 13th Amendment, what's the 13th Amendment say? It abolishes, 13th Amendment abolished slavery and involuntary servitude. So he's literally comparing being in prison to indentured servitude, even though they won't let people in prison work for money. They won't let you do anything. They third party it out. Thank you, Kimber. That's very nice of you. Taking me off my rant. It was a stopgap. Like, I'm like, what the fuck? Who does that? Their logic is flawed, though flawed is creative. I'm like, dude, stop. Stop. I want to know who those jurors were, and they really came back with a not guilty. I just find that so hard to believe. That's all I wanted to look for. I had no idea they were trying to let this fool out. I had no idea. You know that the word jury in his docket is used 147 times. He waived his right to a speedy trial. This is crazy. This man was an animal. So it's some Mexican cartel. I just can't even with it. They wanted to sequester the jury. That was denied. This is in the first trial. Jury selection, jury instructions, transcript of the jury trial. Motion to release evidence. Where's that conviction? Petition for habeas corpus. Witness list. Who was the defendant's witness list? I wonder if they released the names of the jury. Witness list, jury trial exhibit list, court minutes. Hearing record. Defendant entered a plea. Verdict form, here we go. Here's his verdict form. This is the first one. We, the jury, was previously convicted. Court 1. We, the jury, unanimously find the state is established beyond a reasonable doubt. Is this 1 or 2? No, this is the second one. Yes. We, the jury, unanimously find the state is established beyond the existence of first-degree murder was committed for financial gain. No. Was especially atrocious. Yes. Yes, 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 yes. So that is the second trial. Guilty verdict, verdict form. That's 19. Do they not submit it for the mistrial? Court reporter's trial. It just says jury deadlocked. Mistrial, jury deadlocked in computer. Then it has the juror numbers. Then it has the court reporters, but it doesn't give an account of Judge Hankinson tells them they can't have certain reports. Where are the forensic reports for samples analyzed? After continuing discussion with the jury, we disagree. Here's what it looks like. I've never seen this. So he's asking, judge is responding, dear jurors, once the expertise have rested or something, once the parties have rested, you cannot be provided with any additional evidence. No lab reports were put into evidence. Therefore, you cannot be given the reports. As a practical matter, the reports are hearsay and would not be admissible if offered by a party. You must rely on the testimony of the analysts along with any physical evidence admitted. Says, where are the forensic reports for samples? Example, report on swab process from the grab bar. Foreman, John. After continuing discussion with the jury, we disagree and cannot reach a consensus. We disagree over what the evidence showed and cannot resolve the difference. Cause, I don't know what that means, cause. Oh, that's the jury that they kept out. That's the juror they kept out. Thank you for the reminder. Oh, well, thank you very much, Kimber. It's very nice. But they don't show the vote count. That's interesting for that Karen Reed debacle, that they don't show the vote count. See if I know anybody that I can ask. Mm-mm. Nobody I knew. Can you imagine letting this asshole out? Wonder if I could get, I know where he lives, the foreman. They went through a lot of people. They went through 118 to seat a jury. I'm going to have to see if any of these people are on my friends list. I don't know, but I'm so shocked. I don't know what Murder thinks, but how long do you think that's going to take? I mean, if the last thing Segura had was January 13th, how long do you guys think that's going to take? Oh, I don't think Young Jerks is convincing about anything but being a jerk. He's being sued for his mouth, so. I think it's crazy. I wonder if anyone's ever tried that. Yeah, Young Jerks is. Yeah, I don't. I don't think she's innocent. Like, not even close. So, I don't. I mean, she's really not. They went from everybody framed her to the family, the McAlberts framed, the McCabe's framed. Now they have no idea. Like, they have no idea who framed her. That's what her last Ted Daniels interview. Like, be consistent. And I will say it until I'm blue in the face. Why didn't they just defend her instead of blaming? If she's innocent, just say, I'm innocent. Why do you cast dispersions on everyone else in town? Makes no sense to me. It just doesn't. Just say I'm innocent. Prove it. Shut up. Why do you got to cast dispersions on everyone else when you really don't know anyway? Because you supposedly weren't there. So how would you know? So why would you blame everyone else? Why would you say you're framed when you could just say I'm innocent, prove I'm not, and shut up? It just doesn't make any sense to me. Really doesn't. You just poured bourbon. Well, congratulations. I should pour bourbon right now. I know. Young Jerks is like, he's got a problem. Like, he's had issues civilly. issues. So I don't know. They just really need to. That's all they had to do. I didn't do it. Prove I did, and shut up. Like everyone else in the world. Why does everyone think Carl is convinced? Because he said he is. I mean, he said he's convinced. He believes that she's innocent. He doesn't believe in the state's case, which I don't know. I don't understand that. I would have to listen to him, and I just haven't had time. But how can you be so convinced of Donna, but you're not convinced of Karen Reed? Donna is like so far removed in a lot of ways, but not the other. I don't know. Patty will tell you, if free Karen Reed, most of them, when you look up, they have tons of criminal records. Tons. And I have to ask, people who are really committed to this Karen Reed case, whether you think she's free or guilty, I have a big question. Why would Turtle Boy, how much is she paying him that what he is doing is risking his liberty? He is cruel, and more cruel. And how much money could she be paying? Because she is paying him. She's absolutely paying him. He couldn't afford to live. He can't afford to just take off and sit in front of a courthouse all day and make like flaccid penis faces, because that's what he looks like. He looks like, his face reminds me of uncircumcised penis. Sorry, just saying. He's not going to spend any. Well, I don't think so. I don't even believe I don't even see how Alan Jackson is still on the case. I don't. He should be off. I don't know about listening to the entire trial or not. All I know is Turtle Boy could soon have a prolapsed anus. His rectum could be falling out like Sarah Paulson's dress. Like, it could be bad. Sorry. He's awful human being. Awful. There is no federal investigation anymore. I mean, literally today, they were like, there's no federal investigation. And then Free Karen Reed is like, well, they could be indicted. There's no indictments. No one's being indicted. There just isn't. Like, how can the state attorney, or how can the federal attorney prove it anymore by not doing anything? Like, it's not. And they never speak out. And she's even speaking out. She gave Hank Brennan permission to speak out. There's no federal investigation anymore. It's done. And then, like, Karen Reed's walking, shut your mouth. Like, why doesn't your attorney just tell you to be quiet? Be quiet, sit straight, look at the judge, show some damn respect for being in a courtroom as a defendant. Just be quiet. She's like rocking in her chair like this, giving Hank Brennan the stink eye. She is messing with the wrong people, man. That is not how you behave. Did you see Hank Brennan stare her right back? He stopped what he was saying, stared right back at her. Be like, girl, shut up. Shut up. Here's Alan Jackson is like buried in his desk. Meanwhile, Chicky Poo over here is losing her shit, rocking back and forth like this. It's not a good look, people. I don't care if you think she's Free Karen Reed or not. You still have to have some sort of court decorum and shut up. Keep your mouth shut. If you want to. It's not going to bode well for her and again. Crash Daddies is, I don't care. I literally don't care about any of that. I don't. The only thing that matters is the trial and the witnesses in the trial. All of this extraneous stuff makes no difference. If she got life in prison, then she could follow Henry Segura's lead. But if you're innocent, just say, I'm innocent and shut up. Why are you constantly going on every opportunity you get in front of a television to frame the next person and the next, or say that they're all framing you? This person's framing you, then this person's framing you, then it's not your car, that it is your car, it wasn't snow, there was snow. Shut up. That's all. Shut up. If she would have shut up a couple years ago, she probably wouldn't be sitting here right now. But because she won't shut up, she's sitting here right now. She is her own worst enemy. That's it. Period. And Hank Brennan is not Lolly. And Alan Jackson is losing his shit. He's like all buried. You barely see him looking up anymore because he's afraid of losing his Massachusetts ticket. The ticket. As he should. You cannot do that with witnesses. You cannot. And that witness, that engineer, is 34 years old. He's risking his entire life. ARCA removed their Twitter. They removed everything from social media. It's just ridiculous. The whole thing is ridiculous. What happened? Oh, the other KCL lady. I don't even know who that is. Like, you guys, I don't go on STS, so I don't see it. Isn't Kathy? I saw on Carl's. Yeah, we know. I mean, I just don't know who it is. 18th, they are back. Both Karen and Aiden on the same day. It's getting real. She should have just shut up. You know, I just remember seeing her walking down the street. Karen, they're screaming questions at her. Karen, you know who did it. We know who did it. Well, then who did it? All you had to do is shut up. I don't think the evidence was all that clear at the time. Well, clearly they've cleared up some of that. But I think, shut up. Shut up. If anyone is ever a defendant, shut up. Stop talking. Isn't that like rule number 1 as a defendant? I just don't I keep saying it. I'm repeating myself at this point. Carl says the jury will find her innocent. He's got a 50-50 shot of being right. I don't think so. And they never find you innocent. They find you not guilty. So I don't believe it. I really don't. I understand that you are definitely, like, there are some people that subscribe to me that are I just think, I'm so sorry. I'm so sorry. How can you watch, even still, if you think she's innocent, watching the debacle that takes place as the side of the people who behave the way they do? Let's pretend she is innocent. Why is she hanging around these people? Why is she literally having a lottery for a freaking bench seat in that courtroom? Why? Why is she having a lottery to have dinner with her? Why is she screaming and hollering for her birthday when she's a defendant in a murder trial? Come on, act it. Like, have some decorum in your life. You're already perceived as a damn drunk. Stop acting like it. She's been flapping her brain, taking her 15 minutes, and her dad's not much better. Someone literally made artwork of those two. I was like, are you kidding me? Are you kidding me? Yeah, he did. Well, he did say Charlie would get a retrial, but he didn't get a retrial. But he's not the only one. Mentor Lawyer said it. There were a bunch of people that said it, so he did get it. I think of all the ones that are wrong the most, it's Mentor Lawyer. Mentor Lawyer said Daniel Rashbaum was fine. You can have a conflict like that. It's fine. Everything's fine. It wasn't fine. That man, that 34-year-old dude with his wife in Facebook, calling him a hero These people are nuts. She was a nut to do that. Go in a Facebook group for free Karen Read. Say, my husband's a hero. He said, you should shut up. Your husband is testifying in a murder trial. Why are you telling everyone what he thinks? No shame in the game. Nobody will notice. We're all together. We all think alike. No, we all don't think alike. It's just so crazy to me. When she did that, when I saw that, Dana is her name. She put herself out there knowing what her husband was going to say before he said it. What, are you kidding me? I don't know if he got it like that or not. I wonder if Gigi knows. He redacted those Jeffrey Lacoste interviews, which I asked him about. He said the personal stuff was deleted. Wonder if he did it or got it like that. Edited, not deleted. I know what you meant. That was insane watching it all. I know. What the personal stuff being deleted, I was like, oh, nice, Debbie Gibby. I gotta go too. It's 8:20. Thank you so much for that reminder. Thank you, Kimber, for the super chats. It's very nice of you. Nighty night. Thanks, Wesley. Man, mentor. Thanks for being. I'm getting my mouth. Murder. Sorry, dude. So apologize. Sorry. I didn't mean to call you mentor. So sorry. So sorry. That shows you I'm tired. The Segura thing's got me thrown. I'm sorry. I'm just so. She may be a rock star. She may get off. She may get another mistrial. There could be a variety of things that happen between now and then. But what I do know is Judge Bev wrote an order. Jury selection starts. Boom, boom. April 1. Have a good day. It's going forward. Like, she is doing this trial. It is not going to be, so she's probably not killing Alan Jackson off, even though he should be. But the first Martini. I know, I'm so sorry. Don't make me. I'm so sorry I called you mentor. Kimber's on a roll tonight. I don't know. I've seen him. Yeah, he does. I met him in person at the trial and at subsequent hearings. Our next hearing, I think, for What's Her Face is March 11th. So next week. Yeah, there's only one. He put out a second angle and called it the net. Well, it was seen if you'd been in the courtroom. It's funny. Well, have a good night, everyone. So sorry. I called you that. So sorry. I'm very tired. Take care, everyone. Bye, Debbie. Bye, Debbie. Bye, everyone. And it's Kimber. Thank you so much. Have a great night. Bye-bye.